তুই তো মেসেজ করবি কর না, আমি কি বারণ করেছি?
Then, instead of intermodal, we think of the adoption versus a matter of yes, included public
এরকম শেষ হবে কবে?
আপনার ওই জন্য ইন্টারমোডালটা এক্সটেনশন করতে
জানালার বেঞ্চ নিয়ে তো বসে।
Twenty-seventh
27th of this month, because the interim order will be expiring on Friday. That month. At 2 p.m. Mr. Bandyopadhyay, we wanted to hear you on the issue.
I understand. I have been told. I will already, although I have argued that
That was told to us. We wanted your argument in the cross of
process. I have argued that anyway, Milord. I don't know.
27th, we will keep it as to be mentioned. If you are otherwise ready, then we will hear
Okay,
it.
Milord,
Or
if I
we will-
cannot remain, then after election, kindly post it.
That you agree, we shall.
Yes, yes. I am giving that consent here and now. So that
Yes.
if I am here, I will give argue. But I all possibility I cannot. I am possible. All
We
possibility I
shall
cannot.
consider, Mr. Bandyopadhyay.
Yes, on the list.
No, I am appealing.
for the respondent in this matter.
But the order impugned is at page 268 of the volume 2.
স্টিকার আনতে বললাম, ফোন করে মেসেজ করা ছিল।
Milord, we are challenging this order. That is the paragraph 8 is the main.
The mode of consideration.
Milord, the court earlier directed us to file an report. In the report, we have said everything. What we have considered, what we have not considered. If the court feels that is a consideration is good or bad, that's a different thing. I am not on that. What is the mode of consideration? What is there? Milord, there we are challenging. Kindly see, Milord, this is the This is the case your lordship knows that we are working within the very limited time. Right? Now we have kindly come to, first of all, we have taken a point of maintainability, which has not been decided by the learned single judge. Maintainability point, whenever it is taken, it should be decided. Two cause of actions mixed together. One petitioner, his question is something. Another petitioner's questions are something. Someone has given preliminary objection, someone has not given preliminary objection. These are the main. Whether that in a writ petition, 2 or 5 writ petitioners having a cause of action on different facts is maintainable. That is the main question that should have been decided first by the learned single judge. I am coming, Miller. Kindly come to my stay application. Now, kindly come to page 5. Page 5, paragraph 4. Response the commission received in excess of 68,304 preliminary objections from candidates for the English PE subject alone. Thus, as per Rule 11 Roman, the commission received more than 1,36,608 academic references from the candidate, also answers as published in the preliminary answer. Therefore, kindly mark it, Miller. 1,36,600 academic references from the candidate. Objections were 68,304 or objected to by the court. Then this is that, Miller, the compilation of question wise objection we have given at page 26. All page 26. That is not much. Kindly consider now. Yes, this is for reference. Now, Miller, to ensure fair and methodical review process. 68,304 only English subject. There are so lot of subjects. Working, I have to do it within certain times. Now, see, establish a mechanism by which all objections were categorized and across 6 defined parameters.
It's pen 26.
Page, yes, this is the objection.
No, page 5 we have seen.
Page 5.
Paragraph 4.
Now, to ensure a fair and methodical review process, the commission established a mechanism by which all objections were categorized across 6 defined parameters, encompassing the full spectrum of possible grievances. These parameters are as follows. Grievances that choice in the preliminary key is wrong in the opinion of the candidate. Grievance that more than one choice in the preliminary key is correct. Grievance that none of the choice in the preliminary key are correct. Grievance that the question itself is wrong. Grievance that the question is out of the syllabus. And grievance that the English version and the Bengali version carry significantly different meanings. It is stated that as per Rule 11 Roman 6, the commission invited experts in the field of English to form an expert committee. The expert committee was headed by a professor in the Department of English of a university. The email inviting experts delineated all 6 parameters on which the experience to review the questions that were objected to by the candidates. The expert committee were provided with a detailed compilation outlining the nature of the challenges raised against each question as per the majority of the candidates organized under the aforementioned parameters. However, the expert committee were to test the validity of the objections on all 6 parameters which are mentioned in the email as per their applicability. Now, look, this kindly see page Annexus C. Annexus C is at page
30.
Question number, yes, page 30. The question number 1 to 15 answers are correct as per the uploaded on the commission's website. Question number similar, this is the details have been given. Now, the experts invited by the commissions were kind enough to accept such invitation, and the expert committee of English PG subject met on 15th October at 11:30 am at Asana building, action areas to answer experts. The expert committee duly convened, deliberated upon such question for which an objection was raised, and finalized the recommendation upon a detailed deliberation. The expert committee found objection with respect to 7 questions to be valid and suggested appropriate changes. All the changes suggested by the expert committee were duly incorporated by the commission in the final answer key in compliance with the rule 11 so and so. The recommendations of the expert committee are final and binding in all parties. The commission thereafter publishes the final answer keys and declare the result. The applications are only annexing the final recommendation sheet of the expert committee. Along with this application, the signature of the expert members in the final recommendation sheet have been marked to maintain their anonymity. However, the commission undertakes to disclose the identifiers of the expert report if this honorable court deems fit and proper. We can give it the records. I have no objection to that. Now, let kindly see D. Now, this is the expert committee's report. Annexed page 30. Expert committee's report.
This is prior to publication of final answers.
Now, accordingly, on the basis of that, whatever the expert committee's report is there, that on that basis, because the final result has been declared, right? Miller, kindly come to Miller paragraph 8. The petitioner respondents hearing to act, it is WPS so and so, and challenging that answer suggested by the commission with respect to question number 3550 of the master series. The writ petition inter prayed for modification of the final answer keys, re-evaluation of the provision and answering, awarding of 2 additional by accepting their challenges. The petition are not homogeneous, neither their grievances are common, nor are the preliminary objections. All are the preliminary objections are different grounds. Now, barring petitioner number 2, none of the writ petitioners objected to question number 57. If you have not raised objection to the question, how can you ask for this then of the booklet series? Question number 39 of booklet D and question 50 of the minute. These are the questions they have not put a preliminary objections among. Even in fact, 2 of the 6 writ petitioners did not raise any preliminary objection to any of the questions. And the writ petition at the behest of such is not maintainable in the eye of law. And that is in the blood. We have made submission initially, then the report we have submitted. In the report itself, we have said so. What we are saying here, that is also in the report. I will show you to the lots of people. Now,
what mode does the court want? What does the court want?
I am coming. Let me take it the main point, fellows. The rules are. I hope court wants what is the mode of consideration? What is the mode of consideration? I am coming. Just kindly take kindly take this rule. At this stage, only one thing is required. Now, similar 11. Kindly come to method 11 first. 11 Roman point. Now, the Central Commission shall publish in its official website preliminary model answer keys after the written test and may invite suggestions and objections from the applicants.
Each 11.
Clause 11 Roman 5. Well, that's page 5 of the KJ. 11 Roman 5. The Central Commission shall publish its official website preliminary model answer keys after the written test and may invite suggestions and or objections from the applicants, provided that suggestion and objection must be submitted within 5 days. So, after publication of such model answer keys and should be supported by at least 2 authentic academic publications. Miller, kindly stop here, Miller. Excepting 1 or 2, no preliminary objections have been given. We have given so. We have given in the affidavit itself, it has been said. Now, the Central Commission form a subject-wise expert committee comprising not less than 2 members in the rank not lower than proposal. The expert committee shall deal with suggestion, objections, if any, received from any applicants. Suggestion I will receive. Expert committee will consider the suggestions and objections. The decision of the commission shall be accepted by the central, shall be binding upon all. Point before the single. Kindly come to the proviso of Roman 5. Provided that suggestion, objection must be submitted 5 days. Publication of such model answer keys and should be supported by at least 2 authentic academic readings, publication. His point is whether the expert committee, they have submitted certain documents, etc. Whether this expert committee have considered all these to authentic academic publication. His grievances. His grievances. Now, in that background, kindly consider this. In that background, firstly, in number of cases there is not there. Kindly come back to page 5. Page 5. In response, the commission received in excess of 68,000 preliminary objections. Right? And
For
from the
the-
SSC, the committee received more than 136,600 academic references. Well, is it possible? If this is an exceptional year we are passing on, because our time limit is there. References give the reasons why this academic qualification, this reference which is given and is not accepted, is not. This will take more than 1 year time. Rather, is it possible I have to publish the result in terms of the order of the Supreme Court? And at every stage, one of kind
That grievances page 30, this, I am just questioning. Expert committee report, it says questions, first one, answer 1 to 15 answers are correct as per the answers key uploaded in the commission's website. Their grievances that while arriving at this recommendation, their academic publications were not considered. This
yes,
is
yes, absolutely correct. Your lordship is absolutely correct.
as
And
per
it doesn't appear from the expert committees. At this, now the court is saying, now you tell us what is the mode of. Well, mode we have said so. Mode we have said so. What we have said. So many applications are there. We have categorized this. He has not said we are not. He is not coming within this category. Categorized. No, beyond that, any categorization was there. He has not said that. Categorization, we have said it. I have shown you lots of the documents. Expert committee has considered which one is correct and which one is not correct. It may be I like, I may not like.
what, what authentic academic publication was submitted by the petitioner
No,
here?
they have given certain books, all books have been sent. Entire books have been sent. Entire chapter has been sent. And all have not given preliminary objection. In so far this case is concerned. This case is concerned. Only kindly come, my lord. Please see, my lord. Paragraph 7. No, sorry, not sorry. Paragraph 8. Kindly come to paragraph 8. Sorry, my lord. Kindly excuse me, my lord. Kindly come to paragraph 8.
Yes, you have placed.
I have placed all preliminary objections have not given the what I am bound by that. If the preliminary objection is there, you have not raised preliminary objection.
So that is pertaining
Some
to the,
preliminary objections are there.
in this application, Moumita, Pramanik and others.
Yes.
So Moumita, there are six repeated. This is pertaining to English.
English.
So
But the questions, objections are different questions.
these 6 persons are not on the same subject.
Same
Subject is same. Question is not same.
No.
Oh,
Question is not same. Number one. Maybe 1 or 2 question common. Maybe. And some persons have not given the preliminary objections. Even.
no, what order you are wanting from us?
Lord, I am asking that kindly consider. I am asking, I am praying to the Lord. See,
Paragraph 8.
I am saying, madam, just kindly, just I have given. Just excuse me, just 1 minute. No,
45.
kindly come to 245, second volume.
যেটা আগে ওরা রিপোর্ট ফাইল
Page 245.
245 yes
We have given our affidavit, report, court has asked report. You decide on the basis of report whether I am correct or not. But the court, with great respect, court can ask for an affidavit from me. And court will be satisfied whether my action is correct or not. Expert committee, I have requested them to be, they are not my employees. They are all are either professors of the Presidency College or Jawaharlal College, Jadavpur College. They are the expert. It is not my expert.
এই প্যারা 5 থেকে প্যারা 7 পর্যন্ত আরেকটা দেখি। ও সেটাই খুঁজছিলাম।
প্যারাগ্রাফ 5 to 7 যেটা
হ্যাঁ, প্যারাগ্রাফ 5
এটাই
to 7
পেজ 245
সেটাই
Kindly come to
grievances of the choice
kindly come to 47 once.
এই জায়গাটা grievances of the choice
এই যে প্যারাগ্রাফ 4 এই আছে
ও যদি 7 পর্যন্ত মোট
না, ওরা একটু আমরা যে পেপার পাবলিকেশনটা যেটা দিচ্ছি সেটা কোথায় ডেট হয়েছে
সেটা ওনাদের বক্তব্য
অ্যাপ্লিকেবলি ইট ইজ নট পসিবল
মোটটা একটু জানো
aired in your paragraph, the 6 parameters which you dealt, paragraph 5 yes, of the stay application.
Is there?
Look, I sent the email. Email was a part of my report.
ও বলছে দিয়েছে
Yes, yes, it is part of the report.
Part of
Then what is the problem?
May I just,
More do you want?
no, I have something very different to submit.
From his arguments, we
Yes.
find they have said that we have nothing more to do under the rules. Whether this issue of dealing with your individual academic publication as provided under proviso for alleged non-compliance of that, there had been non-compliance of that, court will pass the order. that this process is faulty.
May I just respond to your lordships?
No,
My
you
lord-
respond,
Yes.
we are trying to understand.
Yes, yes, yes.
As per rule 11.5 proviso,
Yes.
I think this will be your argument that
My-
we argued that the academic publications which we have given, there is no element to show in the annexure D that expert committee which has that has considered that.
May I just respond to this? My lord? Rule 11, 5 and 6, there are three elements of Rule 11. First is this suggestions stroke objections. Suggestions are voluntary. They may take my suggestion, may not take my suggestion. But statute categorically uses two words, suggestions and objections. One, when there is an objection, there has to be an application of mind to decide the objection. Secondly, two academic authentic reports were called for. It's a statutory requirement. The question arises why? Today, Commission cannot say that we are overloaded with work, we have time, I cannot see this.
Correct.
When the statute says when it is to be done in a particular manner, it has to be done or not to be done at all. Third element to deal with, three elements. Objection.
Mr. Laidi, what we are wanting to know from you, Commission says that this is what I have done.
Yes,
This is my report, this is my parameter.
yes.
In terms of the rules, according their explanation is this individual academic publication, assumably that has not been considered by the commission. Whatever, because on the voluminous records, this plea cannot be taken. This will be the final judgment of the court.
That is my humble submission. At this stage, your lordship do not entertain this appeal. Because if your lordship
No,
entertains
we
this
will
appeal,
clarify
yes,
that whatever has been written in paragraphs 4 to 7
of
4
the
to
order,
7 of the stay application,
4 to 7 are stay up.
Stay application.
Yes, yes,
stay application,
yes, yes.
Has already has
this has been this is the manner in which they have conducted. The expert committee has given its report. They have nothing more to say.
And based upon the available records, it would be done. Whatever report they have filed.
Yes.
Yes,
Then
my lord,
how-
kindly.
How you are prejudiced?
I am not
because
at all
they are-
prejudiced.
Suppose they are
Yes,
they will not be able to show this that we have dealt with
I know
each
this.
and every academic qualification.
Yes, yes.
Mr. Bandopadhyay says that what more I will
More
say,
I will say.
whatever I wanted to say, that is reflected in the
Yes, yes,
report,
yes.
and we will add to that the report and the statements and amendments made in paragraphs 4 to 7. This constitutes the entire action of the commission and the expert.
The modus operandi of the whole
This is-
process and this
Now, whether
Yes.
you are right that when there is an objection, there has to be a
application of mine.
Mr. Lahiri, kindly consider
Yes,
it is a question of implementation of the statute. Suppose today, if there is a one student, one manner of application is possible. But if there are 10 students, that is why the commission has earmarked the objection that what will be the 6 parameters for the initial segregation of the complaint. Now, when you are questioning a particular answer, naturally you are providing an academic support to that. Now, suppose I am the expert committee. In my resolution annexure D, I have not stated that I am arriving at this conclusion that answer is correct. I am arriving at this answer is correct, but I have not explained my result, that how I have found the answer to be correct. That is the crux, because in considering that, your qualification will be considered. So we will only say that Mr. Bandopadhyay has submitted that the procedure followed by the commission has been disclosed by way of a report, and for abundant caution, commission has also noted in paragraphs 4 to such and such in the stay application as the manner in which the objections have been dealt with. Over and above this, they have nothing more to submit.
my lord, may I just one humble submission before lordship. My lord, if your lordship kindly takes paragraph 7 of the impugned order. I'm placing before lordship. Kindly take paragraph 7 of the impugned order. From the report filed by the commission, it is not very clear as to whether the academic publications filed by the petitioners were considered or not by the expert.
They have not considered.
Yes, I'm coming to that, my lord. It was the lack of clarity which compelled the honorable single bench to pass this order that you show how you have considered.
Record it.
Yes. I'm on that, my lord.
More than this, they have nothing else to say.
And my lord, based on the records, the case to be decided.
Yes.
On the yes.
Yes, finished.
Before that, Mr. Lahiri, before that, this issue is to be also considered. Whether joinder of cause of action is.
That is open for the single bench to
No,
decide.
Mr. Lighty,
He is raising.
he is raising. Why he is raising? There is sometimes subject to correction. Point of maintainability, court can keep it open. There's
Absolutely.
no problem with it.
Absolutely.
But if the council insists that please give a finding to my argument of non-maintainability, then except in cases of habeas corpus or other constitutional violation, the usual procedure is the court will first conclude the maintainability.
Absolutely.
Maintainability, what will the court say? Court may maximum say that this joinder of cause of action is not proper. Individual persons can come with it.
Yes.
Yes.
That should be left open for the honorable single bench to decide. No problem with that, my lord. First day, this prayer for maintainability
No,
was
tell
not
us,
made.
Mr. Lyrie,
Yes.
if we pass this order, recording your submission, paragraph 7, why the court was persuaded to write paragraph 8.
My lord, may I just give the reason why court was compelled to pass this order
Paragraph 7 is the persuasion.
and why the confusion came up? That's why the confusion came up between the mind of in the mind of the court. That I need to show. Then your lordship, my lord, kindly
Tell
consider.
us.
My lord, your lordship has seen Rule 1156,
Hmm.
which says consideration of the academic authentic record and dealing with the issue. Deal, the word used, deal with.
Mhm.
Deal with and objections, suggestions, stroke objections. In light of that, my lord, kindly see why this confusion came. Page 26 of the stay application. I'm sorry, page 25 first. Page 25 is a notice dated 16th of September 2025, where commission, in addition to the statute, comes up with the same provision that you have to give the academic records and everything. We will go into. Kindly see, this is the notice.
No,
It is,
that is in terms of the
yes, now my lord, kindly take page 26.
submit. They will be.
Yes.
They will submit objection. Huh?
They have only resorted to Rule 1156.
Right.
The specific procedure is there. They never said we cannot consider voluminous documents. You have to give, we will consider. Now, my lord, kindly take page 26. 26 is the nature of objections. Kindly take the right hand side, extreme right hand side, correct answers as per challenge. They have taken the majority objections. It was not there in the statute that you have to take the majority objections.
Majority objections
Means, suppose, my lord, 10 objections have come. 8 persons say instead of option A, option B will be correct.
No, in this petition,
Yes.
which question did you challenge?
2 questions were challenged.
55 and
39 and 57 were challenged. So in
all the writ petitions. Other writ petitions, there are 4 appeals.
no, those are different questions. Those are different.
Those are
No, those are different.
24 petitions.
but the order is the same.
Order is the same. I come to your lordship. My lord, kindly see, now there's a first violation. They say the majority objections will be considered. They have taken the majority objections.
Where?
Page 26.
Yes.
Right hand side, kindly take the right hand side, correct answers as per challenge. They have taken the majority objections. Suppose there are 10
So
candidates.
where do we find that?
That is there in their report. I'll justify it. It is there in their report. That
Majority objection means
suppose, my lord, there is one question. 10 persons have raised objection. 8 persons say instead of option B will be correct. 2 persons say no, option D will also be correct. So they take 8 of the objections, but it is not there in the statute. Statute said all the objections. Every individual, they are paying 100 rupees for each questions. 68,000 candidates objected into 100. We paid 100 rupees for one question each. So we expect, this is my legitimate expectation, that my objection will be considered.
Mr. Lighty, we are not on the contrary. If we pass this order, they will be stopped from relying upon any
Yes.
further material.
I'm just showing why the confusion.
So they are saying that court has now asked me to explain the mode of consideration.
Yes.
I have explained in my manner the procedure I have followed. I have filed a report. I have averred in the stay application. Over and above this, I have nothing more to say.
Yes. Problem is they failed
And-
to justify.
I will say that
Yes.
over and above this, they have nothing more to submit.
Yes.
And they say that let the writ petition be decided on the basis of this report which we earlier filed?
Yes,
And
yes,
the amendments I have made in the stay application.
yes,
We
absolutely.
will record that and we will say that this direction to file a further report, we will omit that.
I have no problem with that.
Mr. Lahiri, we
Right.
cannot see it in appeal over the.
No, absolutely not.
Expert committee.
And that is my submission.
Whether the process which is required to be followed by the expert committee as mandated by the statute has
Yes.
been followed or not. It is only the lookout of the court.
Yes, yes, yes.
Okay,
Yes,
we
yes.
cannot sit in
Yes, yes.
appeal over the decision of the expert committee.
Yes, yes. That will be decided by the single bench. I'm not
Expert
giving my
committee
consent here. I have the other submission. I have the judgments to show that court can. When there are demonstrable errors, court can do it. And my lord, only yes, yes, yes. Only one, my lord, I'm apprehensive about one thing only. This should not act in my prejudice. The commission might come up with and say that, see, this is the parameter the honorable division bench has fixed, beyond which it cannot. If the court
No.
wants to make any query,
We have not passed the order. Listen to our
very well,
order.
very well. I leave it to your lordship. I leave it to
We
your
will
lordship.
say this, that over and above the report which has been filed and the amendments made in paragraphs 4 to 7 of the stay application. Please check up
Yes,
4
yes.
to 7 of the stay application.
Stake application.
The commission has nothing more to add,
More to add.
and as such question of filing any further report would be an idle formality. Finished.
Absolutely, based on the records. Very well, very well.
No,
Very
yes, only one thing regarding maintainability. Yes, regarding maintainability, I have read taken the court is first court should decide the maintainability point first. That point kindly clarify, kindly see the judgment.
No, Mr. Bandyopadhyay, that we cannot say.
No.
Or whether maintainability you are,
Second that point.
that has been left open, you can argue on that date also.
That's the reason court must decide the point of maintainability, my lord. I have taken the point. Kindly come to paragraph 9 of the judgment. Then the question comes whether court will go on merit or not. I have taken the point of maintainability. Kindly see, if the ban contained in third clause section 11 of the applies, the corollary is that petition filed by the landlord has to be expressed on the first ground that the landlord was then not entitled to file it. In such a situation, the court should not enter into the merit, because whatever is said or put on the merit then be without it. The High Court should have this is the factual.
রিপোর্টেও আছে
13 and 50.
রিপোর্টেও আছে
With your lordship.
Actually,
Kindly excuse me, madam.
yes, yes.
13 and 15, 13 is the same parameter you are referring to.
No.
Majority.
Not only the majority which we are here arguing, that I have said so.
একটা question example দিয়ে বলছি
We have given a one example.
already part of the reports filed before the single bench. These are already
13, paragraph
all are
13.
part of the reports. They have given exception to the
Very
report
good. Why?
also.
It is there.
It is before the honorable single
We
bench.
want to know whether 4 to 7,
Yes,
paragraph 13 and 14
they're all part of.
mentioned in the report.
Yes. All are in the report.
I was trying to
No,
find
no,
out
don't
the
have
paragraph
something
5. Paragraph 5.
My dear is there.
Yes. Yes, paragraph 5, but
Your lordship is referring to
paragraph 5,
page.
it would be easy to find out since it
কোন
has
page টা?
been divided.
Your lordship is looking
Other-
at
Page number?
246.
No, page 5 of the stay application.
Page 5.
Stay application
Yes.
4 to 7.
4 to 7.
7. On our preliminary reading of the stay application, we find that here mode has been explained to certain extent.
Yes.
Paragraph 4 to 7. Now, we are thinking that whether this stay application will be placed before the learned single bench
Justice
Or-
Chakraborty said that your lordship is
we are
going
to court.
court. Best is court.
Yes.
We can produce, we'll have liberty to produce the stay application. Apart from that,
Whether
my
it
lord,
would,
So we will record that.
whether it would be treated as a part of record. The application you will place, whether it would be treated as a part of record.
by the division bench, if it intends, me not, why not? But it's on affidavit. It's on affidavit.
4 to 7, why you are telling paragraph 13
13
and
and 15, you are adding.
But there is another argument which has been advanced, regarding this majority. That we have answered. Majority, out of the total 10 objections, if 8 have objected to a particular question or a particular parameter, then majority have been taken into consideration. We have sought to explain that in paragraph 13 and 14. For the present, we are, as my learned senior pointed out to your lordship, paragraph 7 and 8 of the order under appeal is troubling us. Kindly clarify that position, let the matter be heard once for all before the honorable single judge. And the question of maintainability we kept open in one of the appeals, in 2 of the appeals. This one, 6 petitioners, in 2 of the appeals, 24 petitioners each, and in another appeal, 1 petitioner.
we are paragraph 13, we find that you have tried to explain what you have done.
Yes.
Objection, what that is on record. You cannot improve upon it. You have taken 8. There were 10 objections.
So
You have
whatever
10 the majority objection.
Yes.
That will be your argument.
Yes.
So we are quoting 4 to 7.
Yes.
Just one submission, my lord. Just one humble submission before your lordship. হ্যাঁ তো তোমরা আমি বলতে পারবো আমার সাবমিশনটা বলবো না আমি
Acha, Mr. Laidi, we are passing.
Yes,
here.
yes.
You-
May
if-
just-
if you want to have anything added, tell us. The present appeal has
তোমার
been
জন্য তো
preferred.
হয়েছে আগে তুমি তো চেয়েছিলে
কি?
তাই ভিডিওটা আছে আমার কাছে। দেখাও। তুমি বলেছিলে তুমি বলেছিলে
Passing, what you want, we
Just-
will say as regards maintainability, we will say that the point we find has been kept token and the commission would be at liberty to urge the issue of maintainability on the next date of hearing.
it is already there in the order.
And have you been given a copy of this? They have relied upon this. এই একটা copy ওনাকে দাও।
And, yes.
Paragraph, please go through paragraph 9.
9.
এটা কি রাধিকা 9
Ashok, present appeal has been preferred
in such
by
situation
the
দাদা
commission and its functionaries. we are thinking this way, will you have any objection if we say that the 427 which you have stated, by means of a supplementary affidavit, you will file before the
Certainly.
court?
Fine, we'll file.
My lord, I,
Milord, what we can additionally do, if your lordship so desires, Milord, we can file a supplementary affidavit only annexing the stay application without the annexures. We
No.
can do that.
my lord, just,
Go to the key or co. Supplementary
my
affidavit.
lord, these points have already been agitated in the report. Let
Petition.
let the copy of the stay application be placed before the honorable single bench. That would be part of records. That will suffice. All points will be there. Again, affidavit, my lord, from 23rd of March, the counseling would be started. Now, affidavit, reply to the affidavit. By that time, the whole process will be ended. So, my lord,
By way of supplementary affidavit.
then again I have to come up with an, otherwise I'll be giving up my right. Now, my lord, let the record of the honorable division bench be placed before the honorable single bench.
That
It will
cannot be
contain-
done.
That
We
cannot
are
be.
disposing of the appeal. We cannot
Yes.
send the records of a disposed of appeal.
Yes, all these records annexed in this stay application is
No,
part
we
of the
will
report.
say we will add 427.
427, that's well.
Put in our order, thereafter they cannot escape from that.
Yes. And
That this is the only ground.
only, and based on the report submitted
That
and
we
the
are
exception.
saying
Yes, yes, yes,
the
yes.
present appeal has been preferred by the West Bengal প্রথমটা পুরোটাই করবে আর পরে
Bench has been changed, my lord. Kindly, my lord, since the lordship understand the emergency of the issue. 23rd counseling will be started.
Third appeal.
No, no. Petition.
Lordship. In the second matter, I will ask him to record that we are giving the number of petitioners, number of objections, and the 6 questions.
That is not
No,
recorded. in the
that is
order.
not.
Should not record it.
No. We have quoted the first prayer which he has made. That
In the
portion.
last matter, the maintainability aspect kindly delete. There is only one petition.
হ্যাঁ, তাহলে তো ঠিকই আছে।
In the last 4, item number 4.
There, no, item number 4, there are
There is only
Chakraborty and others.
No, one.
one. It has been state and everything.
Yes.
Farooq Chakraborty is the lone petition.
একজন
And others বলছে ও স্টেট ঢুকেছে তাহলে আইটেম নাম্বার 4 এ একটা নোট লিখে রাখো ওটাও ছাপিয়ে দিও আমাকে
অরূপ চক্রবর্তী
আইটেম নাম্বার 4 টা লিখে রাখো অ্যাজ
বাকিগুলোতে 24 করে petition আছে।
24 হ্যাঁ? হ্যাঁ, তাহলে ঠিক আছে।
পয়েন্ট আসবে then we will omit the argument on maintenance
Maintainability in the 4th matter.
ওইটাই তুলতে হবে।
omit the argument of maintainability in
Grateful to
item
lordship.
The affidavits of sale.
উপরে evidence of third
এইগুলো
known
দেখে
as by the county kept on.
আচ্ছা, go out of it.
এটা করে একটু আমাকে দুপুরে পাঠিয়ে দিও
But I have a prayer, my lord. Lord, in this matter, Mr. Shishwanna Bandopadhyay was appearing, my lord. I am just seeking time, my lord, in this matter. The state is an appellant, my lord.
This matter, my lord, is similar to item number 16,
Yes.
where we have filed our affidavits. So I was praying, my lord, in this matter also, if direction for affidavit is granted, my lord, then
there is a delay you are not opposing
delay, yes. Delay I'm not.
you are not
No, I'm leaving it up to a lordship, my lord.
16 is also same order, if I'm not wrong. Right?
16, my lord, we have
what
similar matters, but in both the writ petitions, similar order has been passed, challenging that 2 appeals have been preferred. In 16, my lord, lordship has
16 there was no limitation
no 16, my lord, limitation was condoned. Yes, my lord.
তাহলে 16 এর ফাইলটা একটু বের করো
ওই যে অজন্তা সামনে।
no why that was filed in time and this was filed after delay there are group of writ petition
No, my lord. Same matter. Only 2 writ petition was there. My lord, single writ petition in both.
then this matter is of the said writ petitioners no 2 writ petition
Two separate writ petition.
so in this case it is Pradeep Kumar Dev
Right.
and in the other one
It was Dilip Kumar Sharma. Now, my lord, has been substituted by Ajanta Sharma.
during pendency of the proceeding
The petition has expired.
so why did the second petitioner file then why this appeal was filed belatedly both the writ petitioners were covered in the first judgment
But it's 2 separate judgments, my lord.
or 2 separate
But similar matter.
oh the issue is
But
filed
Issue is identical.
day.
Identical.
16
Right?
Same date pass.
ষোলো নম্বরটা এটা তো নেই
একসাথে করবে।
হ্যাঁ আমি নেই
কত
আপনি করে দিয়েছেন স্টেট
Your opposition has.
I have five. Yes, yes, he is coming. One of the junior.
Yes, yes.
হ্যাঁ উনি আছেন
That's. The item number 16 dot.
Item number 16.
ষোলো নম্বর আইটেম
আপনি আছেন
তোমার নাম রেকর্ড আছে
অজন্তা শর্মা অজন্তা শর্মা ওটা রিপ্লাইটা দেবেন
Reply is ready.
Yes,
Your reply is ready. You
So affidavit reply.
I am for the response.
My lord, I am appearing for the petition. My lord. ছবিতে গুটিয়ে দেবে ছবিতে গুটিয়ে দেবে হ্যাঁ
Has to be an evidence. Has to be an evidence.
man. There is 53 days delay, my lord. My lord, another thing, my lord, my humble prayer, my lord. I want to file supplementary affidavit to bring all the factual backgrounds, my lord, behind this case. If you lordship,
They will use opposition.
yes, my lord,
My lord, basis
so,
of the,
so in the reply,
basis of
I
the,
shall bring all documents. Oh, sorry, my lord. Sorry.
What you are saying?
my lord, basis of the, my lord, the document that is Commissioner of School Education passed order in favor of the writ petitioner. That order was challenged by the District Primary School Council Howrah. Went
Lord,
up to the,
dismiss.
my lord, the division bench, my lord. The
Dismiss.
commissioner's order is required and appointment, everything has not been annexed, so those are required. These are the vital document. Otherwise, his count
So
would
I shall annex all those documents in the reply, madam.
They give a supplementary.
Supplementary,
Yes.
yes, madam.
আপনার সুবিধা হবে।
Certain cell will give them application.
আপনি হাওড়াকে দেবেন কিন্তু ওদের নেগলিজেন্স যে থাকে ওদেরও পার্ট আছে।
Or they open here. Stop after hearing that chat room is a discussion part.
is in code number 7, my lord.
Wait,
I'm to
just understand what. Yeah.
reply, my lord. Person of the lordship.
Ask him to come.
My lord, one matter is going on currently.
Let him finish and come. Yesterday also it was taken.
My lord, may I inform my lord?
Yes, where is the ordering queue?
In my stay application, page number 270, 281 to 284, my lord, in my stay application. Therefore, adjournment of the lenient brief. Earlier 2 times I have served the notice as well as memorandum of appeal, stay application and supplementary affidavit to the school authority. Earlier 2 times, my.
What happened? Huh?
He's coming, my lord.
Coming.
May I start, my lord?
Show us the order. Page.
Page number 281 in my stay application.
Yes. Take your seat.
Yeah.
Where is the 8th June 2017?
My lord.
8th June 2017 order.
8 June 2017 order. Page number 265, my lord.
Reasoned order, my lord. May I place it before your lordship?
ওকে বলতে দেন, আমি আগে বলি, আমি তো অ্যাপেলেন্ট, তারপরে আমি আসবো। My lord, your lordship is page number 260.
Please take your seat.
Now, my lord, kindly have a look, my lord, to my opposition. Once, my lord. Page 11 of my opposition. Annexure R1.
Page 11, my lord. My lord.
Lord, 274 kindly.
Okay,
আমি খুঁজে আমার অ্যাপয়েন্টমেন্টের প্রডিউস করেছি কিন্তু অর্ডার P5 কাজ করছে started on 274 মামলাটা যেমন অ্যাপয়েন্টমেন্ট লেটার জয়েনিং লেটার দেখিয়েছে তারপর 250 থেকে 8,500 পর্যন্ত মাইনে হচ্ছে সেটা দেখিয়েছে মানে রেজিস্টার না that is why I have to place one after another, my lord.
First you go through Monindranath Sinha.
My lord,
First go through the judgment of Monindranath Sinha.
lordship.
If there is no sanction post, question of regularization witness.
That is correct, my lord. That I know, my lord. In spite of that, I am placing the facts, my
No,
lord.
no, why in spite of that you first cross the hurdle?
That is why I am placing, my lord. Your lordship, for a moment, only 5 minutes, your lordship,
Hear you.
allow me.
We will hear you.
Lordship,
We are
it is
putting
not
a
sanction post.
Hmm.
Petitioner was appointed by the school authority without violating, neglecting the rules and regulations. It is correct. In spite of that, I am placing
Placing what?
the facts which was happened in the 1991, my lord.
Very
That is
well.
why I am placing, my lord. You, for a moment, your lordship kindly see my reply, my lord. That is why I have
We are
stated
putting a question to you.
that is,
First satisfy the question, then show other facts. That there was a sanction post in which he was appointed. We cannot move beyond that.
At that point of time, it was not there.
So in 1991, when you were appointed, it was not there. You were not engaged by way of any advertisement also. Only a letter of appointment was given. Subsequently, many things have been said. Forget about everything. If you can show us that in 1991, when you were appointed, there was what was the structure of the school, whether it was a junior high school or 4th-class junior high school or 10th-class junior high school, whether you were an organizing staff or not. This you have to give, na? Today the door for regularization is permanently closed.
That is correct, my lord.
Correct বললে তো dismiss করে দিতে হয়. We are asking you.
That is correct, but in this regard, I am pressing, my lord, the school authority in my supplementary affidavit, pursuant lordship direction. In my supplementary affidavit in the lordship, for a moment, my lord, I am pressing.
Supplementary
For a moment, my lord. The petitioner moved an application before the High Court. The school authority,
Mr. Vandari,
lordship.
have you I mean the thing which I am saying to you, can you show that it was a sanctioned poster?
No, my lord, that at that point of time it was not there.
Then how can we direct regularization? Have you brought Monindranath Sinha, Alok Jyoti Moitra?
I've read it, my lord.
You have read it?
Lordship.
Where is it? Have you brought Monindranath Sinha?
Just it is not with me, my lord, but
Then please
I know.
go through it. Don't waste our time. Go through
In spite of that, I am.
In spite, nothing will happen.
Yes, my lord. That is why I am pressing on your lordship. See for a moment. Last annexer, my lord. My lord, at that point of time, though the post was not sanctioned due to pressure of the students, school authority engaged some volunteers, clerk, peon, etc., teacher, etc. So my respectful sir, in the year 1991, your lordship, at that point of time, in another school, 2 schools, the staff of the said school moved application, pursuant to the court's order. They were appointed. They are getting the pension. Page number 289 for a moment in my stay application. 6 times I moved the writ petition before the High Court.
What is your age now?
Page number 289 for a moment.
What is your age now?
Age 68. 68. 68. In the year 2017, I have crossed my
age of
superannuation. So my your lordship consider my predicament. Thereafter, your lordship pass any order. First one, whether my appointment is 289. First time, my respectful summon, your lordship, whether my appointment is genuine or not, it is my humble request. Your lordship kindly see. At that point of time, there was no administration. 289, my lord, in my stay application.
Yes.
Paper book file.
Another.
Paper book file.
File your paper book, we will finally hear.
My lord, kindly once have a look, my lord, into my lord, my opposition, my lord.
When
Page
can
11.
you file the paper book?
My lord.
Paper book, when can you file?
Page 11, my lord. Once have a look, my lord. Kindly, my lord.
Your lordship, according to lordship description, I will file paper. Otherwise, your lordship.
Reply you have given, Mr.
I have given the reply. Well, for a moment, your lordship, I want to place only one sentence, my lord. Whether my appointment was genuine or not, that is why I am placing the first point. You lordship can see here for a moment, my lord. So many documents I placed, which will be proved that the petitioner's appointment was genuine. In spite of that, the school authority submitted before the court that the petitioner appointment was fake. That is why I am placing before your lordship for a moment. The managing committee at that point of time.
File your paper book, we will hear.
Lordship, I have.
My lord has seen the reasoned order.
According
appeal should be decided.
Kindly, my lord, once have a look, my lord, to my office.
Sir, we are hearing the matter.
The appellant is directed
Yes, what you are saying.
My lord, R1, my lord. R1 of my opposition.
আচ্ছা ও 289 দেখেনি yes what 289 you are saying
289, my lord.
yes
My respectful submission in another school, Korinabi DBS High School, Alok Kumar Mukherjee. At that point of time, he moved an application without any sanction post. The school authority appointed himself. He moved an application before the High Court. And thereafter, your lordship, page number 289, my lord.
289 is a typed copy where is the order where is the order of the judge 289 এখানে
পশ্চিমবঙ্গ সরকার দিয়ে দেখাচ্ছে
অলোক কুমার
My lord, your lordship,
orderটা হয়েছে তার আগেরটায়
I am placing, my lord.
Negative equality cannot you claim. Regularization of service in respect of one post.
That, my lord, page number 286, my lord,
yes
post order.
we have seen yes
Let's-
what you are saying
My lord, R1, my lord, page number 11 of my opposition. This is a letter, my lord, communicated by the concerned headmaster of the concerned school, my lord.
that
to
he
the-
is not working
My lord,
that he is not working
my lord,
Has not rendered any service
has not rendered any service, my lord.
for any post in this institution. Affidavit in opposition.
I have stated, my lord.
এটা কি আপনার চাবি?
Against that, I have stated everything.
হ্যাঁ, হ্যাঁ, এটা
এবার দিয়ে দেয় এবার দিয়ে অর্ডার দিয়ে
হচ্ছে কি বললাম? না, আচ্ছা তাহলে হাত জ্বালানো ঢুকে থাকে হ্যাঁ
If the petitioner did not work, how the headmaster issued a letter to the district university school that I do hereby authorize Pinakinath Bhattacharya, who is the petitioner herein, to take delivery of the approval letter of Sri Vibhas Chandra Das, assistant teacher on deputation vacancy. How it was done, your lordship, can you see for a moment?
yes next matter
Grateful lordship.
Obliged.
The 8 and 9, but I am for the school authority respondents.
I appear for the appellant. Page 61 is the judgment under appeal.
In, oh, interest to be paid to the petitioner to be recovered.
To be recovered.
That portion you are
Yes, yes. My lord, I have in the meantime retired.
You have got all your dues.
No, no, no.
You have not got the benefit of this, or you are the state, oh, DI.
No, I am the district inspector.
Where you the district inspector? When was this order disposed of?
This was disposed of on 15th March 2022, first day motion stage without affidavit.
That has been complied with.
Yes, complied with.
Now you are only agreed by page 65, the second paragraph.
Yes, recovery part. And my lord, the respondent writ petitioners are not contesting. There was a query by your lordships to the state. State was given opportunity to use an opposition. No opposition used. The query of this honorable court was whether you want to recover it from me.
State ke appear করছে?
My lord, I am appealing for the state only in respect of item number 9, my lord.
Same order.
Similar.
Item 9.
Item 9.
Identical matter.
Item 8.
You are in, who is in 8?
8.
Yes, Mr. Dhol. As the court will direct.
No, has been communicated. It is the only point that there is no order in issue.
Department is in passive mode to file any opposition in this matter, my lord. I also talked to them, and I even
How much interest did you pay? How much money was paid?
on net amount. The interest part has also been paid, my lord.
How much is that? You are for whom?
I am for the school authority.
School আর কি করবে?
I am on the conduct only. Conduct of the DI. Because of that, my lord, school had to suffer for 4 years. And the person sitting in a government office, my lord, he will abuse all his powers. And the school, it's all non-mission. It's run by the sisters only. They were made to suffer for 4 years. Every day they will go to DI office and come back. No, this will not be done. This, that. Russia will kindly see from the, and the employer is the principal secretary. Principal secretary has held, yes, he is guilty.
Absolutely based.
And that is matter of fact, my lord, it is unchallenged.
Is the matter.
But the statement of fact that has been
Lord,
forwarded
please.
to me, my lord, it kindly be taken.
Yes. 15th of March 22 is the order.
Yes, my lord.
Have you retired or you are still in service?
No, I've retired. 31st of March 2025, I've retired. 31st of January.
31st of January 2025, you have retired.
Yes.
Yes, what is the wrong?
Lord,
with this
if
order?
my lord takes my affidavit in reply, I've done it in a nutshell.
Affidavit in?
Reply.
Where is that?
Lord, I filed it on the previous occasion.
Yes.
My lord, this was affirmed on 9th February 2026.
Hmm.
Please turn to my lord page 3. I'll just place my lord paragraph 6A onwards. I say that without approval of appointment from the competent authority, no salary can be requisitioned and or disbursed. It is evident from the order dated 30th July 2021 passed by the Principal Secretary, School Education Department, that the school authority in the instant case could not produce any post-sanctioning memo issued by the competent authority. It is in such circumstances, Lordship has that, my lord.
Okay, give us 2 minutes.
Page 3. Page 3 of my affidavit in reply.
Your date of joining of the staff was 19th August.
As a district inspector,
The DI altered the date from 30th July 2020 on date of the principal secretary order.
yes,
The date of actual joining.
yes.
What is that date of actual joining? 2017.
19/8/2017. Well, I was not there at that point of time.
Just a moment.
By statement of facts, my lord.
দাঁড়াও। When did you return? 31st of January 2025.
Yes.
Yes, now place your case.
But please take up page 3 of my affidavit. in
Make
reply.
it brief, na? This is the short issue.
Short issue.
Uh.
Firstly, my lord, there was a recruitment procedure. There was a recruitment procedure which required,
No, the principal secretary passed the order
yes,
in 2001, 30th July 2021.
Lordship is looking at, my lord.
Order of the court which you have essayed.
Yes.
Please give us in short. 30th July 2021 was the order of the principal secretary.
Correct.
Please give the page number of that order.
Page 143.
So DI was directed to take steps for approval following the existing norms.
Correct.
within 4 weeks from date of receipt of the order.
16th August 21, I handed over charge.
Now this 4 weeks takes us to
My lord, 30th of August.
30th of August 2021. Then what?
Page 136.
Just a moment. Page 136. That
Yes.
is what?
My lord, I handed over charge on 16th of August. And 23rd August 2021, my successor in office accorded approval.
So what? This order was passed. You were in 15th of March 2022.
Yes. Impugned order was passed. My lord, I have demonstrated in my stay petition that for the relevant period, there were 4 district inspectors. Only I was made a party. I was served with a copy.
You were made a party by name.
By name.
Yes. Now tell us what has happened.
Firstly, my lord, there was a recruitment procedure which required certain documents to be filed. Those documents were not filed by the school authority. Secondly, there was a shifting of the office, as a consequence whereof, my lord, we couldn't trace out the records. Thirdly, the competent authority, he arrived at a finding based on the peon book of the school that in place of so-and-so person, these persons were appointed. Thereafter, my lord, approval was accorded. Unless the competent authority accords approval, my lord,
But the competent authority, DI.
no, I couldn't have done so, and I have attempted to justify my conduct because there was a recruitment procedure.
Show us that 30th July 2021 order of the principal secretary. That has not been challenged by you.
No. Page 143.
Yes.
My lord, this is 23rd August. July.
In your reply, page 8.
My lord?
In your reply, page 8.
Yes,
page 8.
Here is also.
Huh?
Page of annex also.
Lord, page 8 of my reply, my lord. Lord, may I read it?
Yes.
Lord, subparagraph 5. The District Inspector of Schools, Primary Education, Kolkata, with a memo number so-and-so dated 13/5/2021. My lord, I am reading from page 8 of my reply where I have annexed. Page 8 of my reply.
Yes.
At the bottom, my lord, subparagraph 5, 4(5).
Yes.
The District Inspector of Schools, Primary Education, with a memo dated 13th May 2021, submitted a report mentioning the fact that the concerned school authority could not produce any documents in original. So the said office was unable to confirm clearly as to whether the appointments were made by the school authority in regular sanctioned vacant posts. He also mentioned in his report that due to shifting of the office from rented building to present building, the office could not find any old records for verification. However, in his report, the concerned district inspector enclosed a copy of the primary teachers provident fund register cum ledger maintained in the concerned circle office, wherein names of 3 retired teachers against whom appointments were made are reflected with corresponding basic pay, DA, HRA and other pay components.
How many teachers?
3 teachers.
Joint writ petition by
No, separate writ petition. 2 separate writ petitions. The third one, my lord, declined to join.
So they were retired teachers.
No, not retired teachers.
The very names of 3 retired.
My lord, the requirement was in whose place these 2 were recruited.
These 2 means.
My lord, kindly turns to page 9. There's a box. Serial number 2 is the respondent number 1 in the present appeal. She was appointed in place of Mrs. Phrase MD Rosario. And serial number 1 is the respondent number 1 in item number 9, appointed against Magdalene's D. Rosario.
So when they were appointed?
My lord, after they superannuated. My lord, thereafter, the concerned deputy director also reported that the aforesaid 3 posts of the concerned schools were not included in the sanctioned post of Kolkata DPSC, as the school is a minority run institution. He also reported that 1 newly appointed teacher out of 3 teachers, namely Srimati Shagorika Mondal, has already been discontinued from her duty. During hearing, learned advocate for the petitioner submitted that the school authority had appointed 3 assistant primary teachers against 3 vacant posts. Vacancy caused due to retirement, and submitted all papers for approval of appointments to the office of the concerned district inspector on 18 January 2018 as per notification dated 3rd March 2016 issued by the School Education Department. But the office of the concerned district inspector of schools did not approve the same, and thereby causing violation of the provisions of the said GO. The school authority also submitted copies of pension payment order of the 3 retired teachers against whom vacancy created. District Inspector Kolkata submitted that he has taken charge of the concerned office more than 1 year after submission of papers by the school authority. School authority could not produce any documents in original for verification, so the office was unable to confirm clearly as to whether the appointments were made by the school authority in regular sanctioned vacant posts or not. He also submitted that due to shifting, again the same reason is, my lord, given. I skip that. Paragraph 6, my lord, having considered the facts and circumstances of the case, relevant records of the case, submission of all concerned parties, representation, and the law applicable thereto, this is to state that 3 newly appointed assistant teachers have been placed by the school authority against 3 retired teachers of the school, whose pay and allowances have been allowed from the state exchequer before issuance of notification dated 3rd March 2016. Hence, the concerned district inspector is directed to consider the aforesaid 3 vacant posts of the concerned school as vacant posts of the concerned school as per paragraph 3 of notification issued by the School Education Department for according approval of appointments as per existing norms. However, as 1 newly appointed teacher out of the 3 teachers, Srimati Shagorika Mondal, has already been discontinued, Shri Mondal shall not be considered. District Inspector shall take necessary steps for according approval of appointments against 2 newly appointed teachers of the concerned schools following the existing norm. Regarding, my lord, this is very important, page 10. Regarding inordinate delay for processing the instant case in the district office and for entire dispute which leads to such type of litigation, the concerned district inspector cannot deny his responsibility. The Commissioner of School Education, West Bengal, is requested to show cause to the concerned district inspector to explain his action. After getting reply, the Commissioner shall take appropriate action. Look, this is not a final finding. This is not a final finding. It is delegated to the Commissioner. Commissioner will show cause me, I will give a reply. My lord, the very next page, the Commissioner show causes me. Not the very next page. I'm sorry, my lord. Page 17. Page 17 is the show cause.
17.
22/9/2021. This is pursuant to the direction of the Principal Secretary.
Yes.
He is hereby directed to let the undersigned know the cause of this inordinate delay as stated above and explain his action within 7 days from the date of receipt of this letter. Page 18 is my answer.
So this was a primary school.
Yes. Maintained by,
Additional DI, you are holding the charge of DI primary.
I was the district inspector, primary education, Kolkata. I was transferred as an additional district inspector in Ranaghat.
You were initially at that time, you took charge on 27 December 2017. School authority, I had in your show cause reply, you have said,
Yes, yes,
paragraph A,
yes.
that you have taken the charge from 27 December 2017 more than one, as it is found that DIP Kolkata, this is school is in Kolkata.
Yes, school is in Kolkata.
So you were the DI primary in Kolkata.
In Kolkata,
You took charge on 27 December 2017.
correct, my lord.
So your contention is the school took time up to 2019 to furnish documents.
Yes. My lord, may I just indicate my predecessor's name?
Yes.
Page 11 of my state petition, I had indicated.
No, you finish off now. What is
Yes.
your challenge, your submission you make? So what was your show cause? What did you say in your show cause that I took charge in 2017? Papers were given completed on 26 November 2019. Very good. Then what you
My
say?
lord, there was a shifting of office.
When? In the year 2009. Probably some papers were in the office could not find a document for verification.
If my lord kindly turns to page 19, my lord.
Page 19, yes?
Yes. The last paragraph. My humble submission is that the matter of approval of appointment was delayed due to non-cooperation of the school authority. The school authority should produce original documents which were shared for approval of appointment. Due to pandemic situation, the office was closed for a long time. As per decision of the principal secretary, all appointments have been approved by District Inspector, Primary Education, Kolkata. I again tender unconditional apology for unintentional delay in the matter of approval of appointments in the teachers of St. Anne's Free Primary School. My lord, this is accepted by the Commissioner of School Education. I had showed the principal secretary's order. He relegated it to the Commissioner of School Education, directed him to show cause me, and thereafter directed that Commissioner shall take appropriate action. Till my date of superannuation, no action taken. This show cause had its natural death. There has been cessation of master-servant relationship.
So why didn't you say this to the single judge? Where is your argument before
No,
the single
single judge, my lord, what happened? Writ petition was served on me. On the very first day in the motion stage, I didn't appear. I didn't engage a lawyer. I was impleaded by name. My lord, my humble submission before your lordships, my lord.
You were not served?
I was served. I was served. My lord, I had my office preoccupations. I didn't expect a disposal on the very.
Expect that this sort of an order will be passed. Go to High Court, bring an order, then I will consider. You have come for interest. Who are you? Go to High Court. This is the attitude of your DIs. Do whatever you can. Government of
The secretary observed that your plea was that school authority did not produce sufficient document to you to proceed further. Have you ever communicated this to the school authority? Rather, you wrote a letter to the commissioner seeking his instruction.
Yes, he's my superior
You have never
authority.
communicated that you have not submitted certain such document, and hence I am unable to proceed further to give accord approval to that appointment. You have never communicated, but you have taken plea and trying to shift the blame upon the school authority, taking a plea that school authority could not produce sufficient document. Where is that communication?
Just give me a minute's time.
And ultimately you proceeded on the basis of the document submitted to school authority earlier. School authority did not submit any document in phase manner.
May I submit this, my lord? The uniqueness
Wait,
or
wait.
ingenuity of the DI, I'll submit.
For the relevant period, there were 3 DIs. I was only made a part.
You have 1 year. You come to page 9, that para 5. He has taken charge of concerned office more than 1 year after submission of papers by the school authority. However, concerned district inspector of school admitted that in the instant case he sought instruction to the commissioner of education regarding further course of action instead of his communication to the school authority regarding his inability to accord approval with cogent reason as the provision of within the stipulated science.
Where is this memo of 5th of June 2020 which you wrote to the director, Commissioner of School Education?
Lordship is referring to page 19.
Page 9,
Page 9,
paragraph 5.
paragraph 5, last portion. However,
Para 5.
Salary of the DI for illegal arbitrary
Contesting.
Petitioners are not.
They have retired.
No, they are still working.
They are working.
Yes.
What is that quantum of interest,
Quantum, who
Mr.
can say?
My
Can you
lord.
say the
That I will
quantum?
ascertain.
The statement of facts, Lordship, kindly, I have given.
আবার বলে statement, I am
বলে দিন না।
wanting the figure from you.
Quantum. It appears that the item number 9, Mousumi Mandal's case, the first amount as principal amount was 13 lakh.
আবার বলে আমার
না,
একটা প্রশ্ন জিজ্ঞেস করছি, তুমি entire details
মৌসুমি 13 lakh.
what will be the approximate quantum of interest?
Approximate quantum of interest in both of the candidates, my lord, it was total 5,79,400.
Can't be. It can't be. Area salary was 5 lakh.
It is.
Interest can't be
What
5.
according to you was the interest amount?
It is the
But I don't know.
Huh?
I don't know. Lord.
How much interest did you?
My lord, kindly says that it is at
দেখি
the
দাও।
last annexure.
কিসের last annexure বলছে? Last annexure of what?
Statement of facts, my lord.
Statement of fact, yes.
The two headings,
Year
Veronica, Bharati Bar.
Interest বাবা প্রিন্সিপালের থেকে ইন্টারেস্ট বেশি।
It is explained at the last paragraph, my lord, at
না না এরিয়ার স্যালারি ফ্রম
5,79,482 to Srimati Veronica.
Yes.
And 2,89,741 to Miss or Mrs. Mondal.
For Veronica and Mousumi, for both total, it is about 5,79,000.
Total 5 lakhs. Total 5 lakhs. And
That is the interest part.
ইন্টারেস্ট হবে বলে
দুজনকার এরিয়াস
your area salary from 19th August to 31st October 2021. Actual payment was when?
Payment without interest, it is about, my lord, 13 lakhs.
58,869.
What?
Total area salaries. Which is at page 154 of my application.
154.
Lord, my successor in office writes for the requisition on 7th March 2022.
Yes, the area amount was 2,71,000.
এটা টোটাল এক একজন হচ্ছে
No, it is
58,800
ঠিক আছে
13,58,869 each.
yes.
My lord.
তাহলে this was ultimately paid when? No, এরিয়ারটা তাহলে interest for the period from 19th August 2017 to 21 তাই তো ওই এরিয়ারের পিরিয়ডটা ইন্টারেস্ট
হ্যাঁ হ্যাঁ
তাহলে
5 লাখ হয়ে যাচ্ছে ওরা হিসেব করেছে 5 লাখ So you are the state, you have paid 5 lakhs to
My
both
lord,
of them.
my lord, 5,79,000 for both.
Lord, I did not serve the entire period as the district inspector primary education. I've indicated that in my petition.
where?
Page 11
Page 11
of the application, my lord.
Page 11 of the stay application.
Yes.
ও চলো এটা
তেজারি বিল আছে তেজারি দিয়ে আছে তো 2,60,000
Lord, 10th line from the bottom, page 11. 10 lines from the bottom. During the aforesaid period, Lordship has got it, my lord. During the aforesaid period, as many as 4 officers served as the district inspector of schools primary education. All the officers were not implemented as parties in the writ petition. Mrs. Shubhra Bhattacharya served from 13/11/2014 to 31/7/2017. Piyush Beda served from 31/7/2017 to 21/12/2017. The appellant petitioner served from
Yes,
21.
Mr. De. You have many grievances, but kindly come to one grievance. Our grievance.
My lord.
Come to the order of the principal secretary. Page 10, office. Have you got it, Mr. De? That affidavit in reply. They are affidavit in reply.
Yes.
Regarding inordinate delay for processing the instant case in district office for entire deal list with concerned DI. Very good. So the commissioner will focus and then the commissioner will take appropriations. Now, the order of the court, that is order of 15th March. Kindly come to the internal page 5. Second paragraph. The interest will be paid to the petitioner shall be recovered from the salary of the concerned DI, for whose illegal arbitrary action there was a delay. Fixation of liability has to be there. Now, in the principal secretary order for fixation of responsibility, commissioner was directed to take steps. Commissioner issued a show cause. He answered to the show cause and retired from service. How can you establish the fixation of liability?
Fixation of liability is the administrative matter amongst the
No,
office.
Mr.
Lord.
De.
What I can show the
We
plight and
understand.
miseries of the school and the conduct a person. Only one submission, my lord.
You have
That will
got the-
clarify, my lord.
You
Only
have
one.
you have got the compensation.
My lord, correct. But my submission is that
The petitioner also.
that's true. Because of the plight and miseries of the school, I have come only to point out before your lordship and pray that a person like him sitting in government's chair should not get blessing from this honorable court. So that
you
tomorrow.
should have said that before the trial court. That mention that this is the person who has
It's not
to pay
because
interest.
absolutely it was clear because he was
No, it's
made a
not.
party by name.
How it is clear,
But
Mr.
a person who is
He
doing
ordered-
mischief for last 4 years,
Mr.
but
A.
what more?
No, answer our query. We are putting a question to you. Page 65, second paragraph. Where is the fixation of responsibility? Tell us.
Fixation of responsibility. Principal secretary says the concerned DI, he is present.
So who
What-
is the concerned DI?
Concerned DI is present before the principal
That is
secretary.
why he has to. The principal secretary said that you find out who is that. Show cause him.
No, principal secretary. What if your lordship kindly reads the order in its entirety? The tenor will come out that the person was present and principal secretary found him guilty, and that is why he told that he must be taken into task. He was present.
Yes.
Kindly see that paragraph.
Who appeared before the
Yes, he was present there.
principal secretary? Who appeared? What
The
is the
DI himself was present.
No.
Present.
apparent before us?
Lordship kindly reads the order 30th July.
Name
But principal secretary was represented by Mrs. Choma Mukherjee and Mrs. Monica Pundu.
No. I am reading the principal secretary's order.
Paragraph 5.
Paragraph 5 of principal secretary's order.
You were not represented. You were not heard.
No, I was not present because I was ADI Ranaghat.
That DI Calcutta submitted.
DI
So
Calcutta.
who are
DI Calcutta submitted my successor in office.
30th July, my lord.
This is of
30th July 2021.
30th July
2021.
2021?
He was present there.
DI
And more so, my lord, I myself was present. That is why I know. I myself was present before the principal secretary.
That is personal.
No, my lord. That is why I say, my lord, I know that he was present.
16th August.
16 August. So 37 July 2001.
He was present.
You are
It is written in the order.
charge of the office of
And
DI.
Commissioner, Principal Secretary found, he is the appointing authority. The appointing authority finds the person to be guilty. and
No, no, no,
hold-
no, has not found him to be guilty, Mr. They
My lord,
find.
what more, in my humble submission to the deepest respect, what more is required principal secretary finds? And such a course of action is,
Principal secretary will stop his recovery.
that he has not done, that is in his wisdom, my lord.
He has
It
not
is not, this order is not under challenge by him.
Why he will challenge?
If he is penalized, if he is penalized on the basis of this order only, the landed signature was found.
You are putting your personal impression over.
No, madam.
Yes, because you are saying after this sort of an order, how can the court pass an order that don't take the money from you? Leave that much to us discretion to the court.
No, that, my lord, I
No, you
cannot
have-
say ever.
No, no, you have made up your mind, sir.
I have only submitted a person
No, no,
doing this
you
kind of
said-
mischief,
You
my lord.
said that after this sort of an order, how you can interfere.
No, this
Yes. No, you just now said.
I submitted, my lord, after this order,
No,
the
no,
landed
how
single
can-
judge
how can
found
he be-
that on
how
the basis of this order, my lord, this order, landed single judge passed the order.
You are an advocate, you make a submission with responsibility. You say that if after this sort of an order, my lord, what you are considering? Close the brief. You cannot urge in that manner.
That, with deepest respect, that
So
I
in
cannot.
that, in
If my lord,
absence
then,
of it,
Lord, I tender my sincere apology for that.
we understand, but in that sense of the case, we wanted an answer from you. That principal secretary, you are right, he was hard. He made
And the concern
submission.
means, my lord, the person himself, because he was present. That is my submission that your lordship will consider. A person, my lord, only one submission, only one aspect that will clarify the thing. A person who is asking for PPO, asking the school to bring the PPO in original, which can never happen. The PPO is with the person who has retired. And that is what is recorded in the principal secretary's order, that since the school could not bring the original, it could not be verified.
Oh,
And this is page 46 of,
come at 2 o'clock.
yes,
Come at 2 o'clock.
Oh. You all are there, we can take up the matter.
my lord.
We are coming back at 2:15.
215, yes. Only one request.
Yes, Mr. De, you're in a continuing matter. Yes.
May I please, your lordship. My lords have considered the reasoned order dated 30th of July 2021. After that, the lordship my lords kindly turn to page 135
Of the stay application.
of the stay application.
Lord, there was a query of the court. I'll answer. I couldn't answer. The query of the court was where
Let him finish up.
After the hearing is over,
Page.
page 135, 13th August 2021 letter. Have my lords got?
Yes.
After the hearing is over, the decision has been rendered by the principal secretary. This is the letter. With reference to above, this is to inform you that 3 vacant posts of St. Anne Free Primary School are hereby considered as vacant sanction posts for according approval of appointments as per existing norms. However, as one of newly appointed teacher out of 3 teachers, namely Srimati Sagorika Mondol, was already discontinued from her duty, the approval appointment against Srimati Mondol will not be considered. The school authority is requested to contact with the concerned section of the office of the DI of schools, primary education, Kolkata, with relevant documents and along with latest enrollment status for approval of appointments against 2 newly appointed teachers. Principal Secretary has already held that you proceed taking into account these posts as vacant posts. Even then, this is given.
They were granted approval from 2017.
My lord, initially, what happened? This letter was given. That is why I was just pointing out. That is the conduct I was trying to show.
We have seen page 135.
135. Then lordship kindly sees page 137, the letter of the learned advocate for the school in this regard, addressed to the principal secretary. (137) the letter. May I read it for your lordship? Only certain portions. Following all the formalities of your order number so and so, my client school submitted the papers and documents relating to appointment of teachers in the school in the office of the District Inspector of School Primary Education, Kolkata, on September 9, 2017, and subsequently afresh on January 18, 2018, seeking approval of
March 2016. Which order?
But 3rd March 2016 is the recruitment rules.
Oh. Yes.
The District Inspector of School Primary Education, Kolkata, sought for instruction from the Office of the Commissioner of School Education, West Bengal, my memo dated so and so, June 5, 2020. Then the school was constrained to lodge a complaint against the then District Inspector of Schools Primary Education, Kolkata, namely Sushanto Panda, the appellant herein, and sought for inquiry against his conduct, including violation of fundamental rights. Then the school moved the Honorable High Court in a writ petition. The Honorable Court passed the order dated March 24, 2021, directing you to consider the entire matter. In compliance of the order passed by the Honorable High Court, you heard the matter, considered all aspects of the matter in threadbare, and passed the order number so and so dated 30th July 2021. Then the operative part of the order is quoted. Then, my lord, last paragraph. Sri Sushanto Panda, Director, District Inspector of Schools, Primary Education, Kolkata, is now posted as Additional District Inspector of Schools, Secondary Education, Nadia, as he was released on August 16, 2021 in the afternoon. On the day of his release, which is the 17th day, the very next day, after communication of your order as aforesaid, Sri Panda continued with his motive to harass the school, issued the letter under reference at 2:25 p.m. in his personal email of the head teacher.
Which letter?
This letter, the 13th August letter, just now I placed before your lordship at page 135, that you bring all the documents. This was sent to the personal mail of the head teacher by the appellant.
13th August, he was there. 16th August,
he was released.
For release, he sent.
Release was on 16th. On 17th at 2:25, he sends the mail to the head teacher in her personal email saying that you send these
After
documents.
handing over the charge.
Maybe, my lord, I do not know. On 17th at 2:25, he sends the mail, and letter is dated 13th. I am just only showing the conduct, this much, my lord. Then what happens? The approval is given from the date of the order, that is 30th July 2021. But the original date will be from 2017. 4 years were absolutely, my lord, gone.
No, can you give the names of the two teachers who were given appointment?
Yes, his name is there.
Mousumi and
Veronica
and the other one did not
join. So that post is not in question.
also. Sagori.
Then, my lord, the department issues letters and ultimately,
So Sagori, these persons were not getting approval though they were working in this.
yes, since 2017.
Now,
Lord, kindly, if you
now 2017 when they were school preferred the writ petition.
initially the school preferred the writ petition.
On the
That-
basis of the order passed in the same, this order was passed by
On the basis of the order passed in that writ petition, the principal secretary heard the matter.
So this appeal is arising out of
The second writ petition preferred by the candidates.
teacher.
Teachers.
after this reasoned order was passed.
This is the second writ petition.
This is the writ petition of Annie's Free Primary School.
Yes.
6199,
Yeah.
30th July 2021.
Just
Page 124, my lord, is the order passed by the court.
the impugned order is arising out of the writ petitions filed by the teachers. But the initial writ petition was filed by the school.
Teacher filed which writ petition, Mr.
The present writ petition.
Present orders, my lord, arising where from these appeals have arisen. Initial order, may I place it? May I just a minute? Just page 124 of your lordship's brief. This is the initial order.
This is the writ petition of the school.
School
On that basis, principal secretary
heard
was-
the matter. Yes.
Very good. Now thereafter, when was the second next writ petition was filed?
Second writ petition was filed on
That is order is at which page you said?
My lord, 20,
124 of your lordship's brief.
My lord,
The
may I-
first writ petition order.
That is 120.
my lord, may I indicate the date of the
Let him, we will. When was the order in?
Impugned order is 15th March 2022. That is second set of writ petitions filed by the teachers when they were not getting salaries.
So the second writ petition was filed after 7th March 2022.
25th February 2022, it
February.
was affirmed.
25th February, yes.
Now during page 154, during pendency of that writ petition, this memo was issued. 7th March.
154.
154 minute. This is
No, this is requisitioning the salary. Yes, yes,
That
yes.
writ petition. এখানে আছে। This order which has been passed WPA 36235 of
Yes.
2022.
Yes.
Writ petition was filed claiming what?
Let me look. Interest.
To pay the area salary along with interest.
Yeah, I look with interest.
now only one page, lordship would kindly consider page 146. Yes, this is the rectification. Initially, the date of appointment, the approval was given from the date of the order, 30th July 2021. That was rectified to 19th August 2017, 4 years back.
This rectification was made
On
Term-
10th of,
terms of the order of joint secretary.
yes,
In terms of the order dated
9 September.
because of the letter of the school just now I placed before your lord.
Yes.
And that in these conspectus of facts, my lord, the learned single judge passed the order which you have, my lords have already considered.
Now, where is that, where is the approval memo issued?
Approval memo, page 46, the first approval memo, page 46.
This is on 23rd August
23rd August.
21.
First, we will kindly consider the dates.
So pursuant to the principal secretary order of 30th July, this 23rd August order
Yes,
was passed.
First. Subsequently, it was
Amended.
rectified at one page 145,
146.
146. 10th of September 2000.
This is the joint for
So the entire 4-year salary was gone initially.
commissioner is given orders everything. Not from the date of his joint. Subsequently, আবার মানে এই যে-
No, no, sir, এখানে commissioner to body. I was saying, since it's directed to consider the aforesaid three written posts, okay? So para 3 of notification
ওরা consider করলো।
for according approval
ওরা
as
approval দিলো এই date
indicated.
commissioner।
এগুলো তো
না, date হবে from the date of joint। তারপরে আমার এই ইস্যুটা রেজ করছে।
joint এখানে বলা।
ঠিক আছে, মানে ওটার করছে না appointment টা। Why is that date? When his appointment, he was appointed. Why is it? আমি আবার 145 আর এটা নিয়ে হলো তখন জয়েন্ট সেক্রেটারি বললো আই এম ডাইরেক্টেড টু ইনফর্ম ইউ টু রেকটিফাই দ্য অ্যাফোরসেড অ্যাপ্রুভাল লেটার তখন ইন রেকটিফিকেশন দেয়ার অফ এইটা 9th আগস্ট থেকে দেওয়া
Yes.
Now, in the light of these facts, my lord, the learned single judge passed the order. May I place the relevant part, my lord? The petitioner was appointed as an assistant teacher of St. Anne's Free Primary School. There were certain issues with regard to selection process, and a repetition was filed by the school before this court. In compliance with the direction passed by this court, the matter was considered by the Principal Secretary, School Education Department, and by an order dated 30th July 2021, the Principal Secretary directed the District Inspector of Schools to consider that 3 vacant posts of the concerned school as vacant sanction posts for according approval of the appointment as per
Where
existing
are you
norms.
reading, Mr. De?
But first page of the impugned order,
Page
15th March.
61.
Last paragraph, the DI primary education was directed to take necessary steps for according approval appointment of the teachers following the existing norms within 4 weeks from the date of receipt of the order and to submit a report to the department. The Principal Secretary observed that concerned District Inspector of Schools cannot deny the responsibility for processing the case and for the inordinate delay in the same. The Commissioner of School Education, West Bengal, was requested to show cause the concerned District Inspector of Schools to explain his action and to take appropriate action against him after getting the reply. The District Inspector of Schools, Primary Education, Kolkata, by an order dated 23rd August 2021, approved the appointment of the petitioner on and from 30th July 2021, that is the date of issuance of the reasoned order by the Principal Secretary. The petitioner filed representation against such action of the DI in granting approval from the date of passing of the recent order by the principal secretary instead of approval from the date of joining of the school in her post. The representation was duly considered, and by an order dated 9 September 2021, the Joint Secretary, School Education Department, directed the District Inspector of Schools, Primary Education, Kolkata, to rectify the date of approval of the teacher. The Joint Secretary forwarded a copy of the aforesaid decision of the Commissioner of School Education to obtain explanation from the DI as to why he did not accord approval from the date of joining. The District Inspector of Schools, Primary Education, Kolkata, by an office order dated 10th September 2021, passed order that the date of approval of appointment of the petitioner should be read as 19th August 2017, 4 years prior, in place of 30th July 2021. The grievance of the petitioner is that her arrear salary for the period from 19th August 2017 till 31st October 2021 has not been paid till date. Repeated representation from the petitioner remain unanswered. Learned advocate representing the state respondents submits upon instruction from the District Inspector of Schools, Primary Education, Kolkata, that the Sub Inspector of Schools, Circle 8, Kolkata, submitted requisition of arrear salary in respect of petitioner for the period of 19th August 2017 to 31st of October 2021. The said claim has been sent to the District Inspector of Schools, Primary Education, Kolkata, to the Deputy Director of School Education, RP, for the allocation of fund of rupees 13 lakhs and odd on by the office memo dated so and so 7 March 2022. The arrear salary cannot be paid to the petitioner as fund has not yet been made available. As soon as the allotment is received, the bill for arrear salary will be drawn and disbursed in favor of the petitioner from Pay and Accounts Office to Kolkata. It appears from the submission made on the behalf of the parties and the documents annexed to the writ petition that the claim of the petitioner for arrear salary has been admitted by the respondents, and the bill to the aforesaid amount has already been placed before the appropriate authority. The arrear salary will be paid upon allocation of funds. The petitioner has been compelled to approach this court on repeated occasions due to the arbitrary action of
Mr. Dev, one thing, the petitioner on repeated occasions approached the court.
Yes.
But this is the
petitioner for the first time and school
for
initially. The court on repeated occasions due to arbitrary action of the concerned District Inspector of Schools. The genuinity of the claim of petitioner has already been accepted. Had the District Inspector of Schools acted in strict compliance of the rules, then the petitioner would have been saved from the trouble of approaching the court for relief. The Principal Secretary and thereafter Joint Secretary on 2 occasions requested the Commissioner to take appropriate steps against the erring DI, but it seems that the DI has not taken the issue seriously. The Commissioner of School Education and the Deputy Director of School Education are directed to take necessary steps for releasing the funds bills whereof has been raised on 7 March 2022. The aforesaid amount shall be paid to the petitioner with interest at the rate of 10% per annum on and from the due date till the date of actual payment. The interest will be paid to the petitioner shall be recovered from the salary of the concerned District Inspector of Schools, Primary Education, Kolkata, for whose illegal or arbitrary action there has been delay in according approval of appointment of the petitioner, resulting in non-disbursal of salary for a considerable period. The Commissioner of School Education shall ensure the payment is disbursed in favor of the petitioner at the earliest, but positively within a period of 3 months from the date of communication of a copy of the order, affidavit of service filed in court, writ petition is dismissed. Well, this is the in the conspectus of facts and events.
In the first application for seeking approval of appointment, along with supporting documents, were placed before in the office of the District Inspector of School. When first?
In 2017. That is what I have placed.
2017.
Yes. That is what I placed. That letter, Lordship kindly sees page 137. September 9, 2017. And subsequently afresh on 18 January 2018, all during his tenure.
No.
So 2017, first, the application seeking approval of appointment along with supporting documents were placed in the office of the District Inspector of School.
Where is that letter? Which letter here?
Page 137. The letter
17th August 21.
17th August 21.
Where it is written, it was placed in 2017.
But after 2-3 lines, my Lordship kindly sees, and
on 9 September
yes, 2017, and afresh on 18 January 2018.
So it is pending in the office of the district inspector of school since 9 September 2017. And the present appellant which Mr. Banerjee is trying to convince us that present appellant was in charge of that office for only for 1 year. Only for 1 year.
No.
So
21/12/2017 to 16/8/2021.
No, no, where is that? You showed us that 4 DI pendant.
Yes, yes.
That show cause that is
Yes.
which page? Show cause is at which page?
Well, fact remains from the list of dates.
Page 11, my lord.
List of dates.
Well, I have made for myself.
No, no. Page 11 of my stay petition, I have pleaded.
You showed us the reply, no? Reply to the show cause.
Oh, yes. Reply to the show cause.
There you stated this.
Appellants are
Page 148.
Page 18 of the affidavit in reply.
The dispute in the case started on 3/11/2016. While you are saying that, Karo, he gave it. It was
Lord, may I read it?
just a second. ওই মেমোটা কোথায়? যে ওই যে তুমি বললে না কবে ডিআই অফিসে দিয়েছো,
ওইটা ওর রিপ্রেজেন্টেশন থেকে পড়ে দিল 9 September.
পেজ
Just you read from 9 September your advocate's
Your
letter.
Yes, yes, yes.
Your advocate's letter, page 137.
137. Yes.
on September 27. India. When did you join
Appellant joined
21/12/2017?
না ওই সময়টা নয় 997 থেকে প্রায় হচ্ছে তাহলে পীযূষ বেরা থেকে হবে পীযূষ বেরা
ওর পিডিএফটা হচ্ছে 9 September 2017.
আর এটা
পীযূষ বেরা 3 মাস ছিল।
পীযূষ বেরা ছিল 5 মাস
3 মাস ওর আওতায় ছিল।
হ্যাঁ মোটামুটি 5 মাস ছিল
এবার এই কথাটা বলছে না ডিসপিউটিং দি কেস
ছিল কিন্তু অনেক
এটা আগিয়ে দিয়েছে শয়তান আছে। There, Mr. De, page 11, he is saying that dispute in the present case started on 3rd November 2016. But your case was that we submitted on September 2017.
My lord, the appointment was made in 19th of August 2017.
কিন্তু from December 2017 to 16 August 2021 you are in charge of
I swear there.
Yes. What I did. Page 87, page 89, page 94.
We will come to you. Let Mr. De
Very well.
finish. Yes.
So, my lord, I need
Here are you.
these are my submissions. Only one second, my lord, at the cost of being reprimanded, I will submit, my lord. Kindly do not place a wrongdoer. This much. My lord. These are all.
Let's see. Yeah, I'm gonna put it. Are you?
There is a recruitment rule. Kindly takes up, my lord, the recruitment rule at page 15 of my affidavit in reply. What are the documents which are required to be submitted by the school authority? This is a statute, my lord. This says that for the purpose of approval of service, appointed through open advertisement.
Page
Page 15.
of stay application.
No, of the affidavit in reply.
School is respondent number 6.
Yes.
Affidavit in page.
Page 15. I'll just straight away go to the relevant part.
Yes.
Annexure 2 in the middle. Below clause 6, cause of vacancy. New creation of post duly sanctioned by the competent authority. Retirement, resignation, transfer, death, termination of service duly approved by the competent authority. Supporting papers duly attested to be submitted.
Where do you?
Below serial number 6, cause of vacancy. Below, this is a document which is required for the purpose of granting approval. What I did, page 87 of my stay petition.
You have to show any other document from this reply.
Only one thing,
You
Milord.
are taking us page 15, then again 87.
Milord, from reply, Milord, let me conclude from reply.
87. 87 is what? 87 is the ADR claim in your stay application.
No, 87, I write to the school because prior to recess, there was a query that did you write a letter to the school? This is 3rd of July 2018 during my tenure.
3rd of July 2018.
Yes.
No, you were in tenure from
21/12/17
21/12/17.
till 16/8/21.
Yes.
87 I write, 89 I write.
But prior to that, your office was having their papers on 9 September 2017. Page 137.
I was not there. I assumed charge on 21/12.
So when you assume charge, this document was there.
Yes.
So this document, they have expressed this mind that principal secretary's direction was such and such. I have provided all the documents. That is page 137. It was given to you on 17th August 2021.
137.
Oh.
No, here what you have stated to be.
No, 17th August 2021, Milord, I have demitted office.
87, you conduct. Now you conduct Mr. Banerjee.
Yes.
He or she is requested to submit attested photocopy of the mark sheet and other relevant documents of race 12 imparent candidates.
Yes.
Now come to page 15 of your EA, where the school authority is obligated to submit the mark sheet, photocopy of the mark sheet and relevant documents of other imparent candidates. You kindly show from 25 numbers of documents.
Lordship is referring to
description of 15 and 16, annexed 2.
page, Milord.
Page 15 of your rule. You stated that this 15 numbers of document needs to be submitted before obtaining approval of appointment.
Correct.
Of any candidate. So you show that here, this document, photocopy of the mark sheet and other relevant documents of rest imparent candidates, all imparent candidates.
Milord, this rule doesn't restrict me to verify and check whether at all there was appearance of other 12 candidates. What is stated cause of vacancy?
Okay, we shall consider your argument, but you show that from this document, from the this annexure, that document legislature asks you to collect from the school.
Please see, Milord, page serial number 12.
12.
Academic qualification.
Serial number 13.
Of whom?
That is not indicated.
Name of appointee to the post, academic qualification.
Madhyamik onwards, attested copy to be submitted.
What you are going to do? You are going to approve or going to take decision whether appointment of the person concerned would be approved or not.
when a statement is made that 15 candidates participated,
So all candidates have mark sheet of all candidates to be
because
deposited.
marks have been allotted, my lord, in the table. All candidates' marks.
That mark sheet of all participants are to be submitted. You show
Yes,
that
my lord, there is
sheet
a
of all.
there is a tabular chart where all the participating candidates' marks are given by the selectors based on Madhyamik, based on higher secondary, based on academic
No,
qualification.
what is my, here you are seeking documents of rest 12
Yes,
expansion
yes.
apart from the petitioners.
Because rest marks are also before me. All marks are before me.
Yes, then what was the problem then?
Problem, my lord, I need to check up as to
Check up,
whether the
check-
calculation is correct.
That your secretary has not said. Secretary said give approval.
No, that was thereafter.
No, secretary's order was 30th of
21, 30th of,
July 2020.
yes.
And this
My lord, I am writing on 3rd of July 2018.
this is prior to
Yes.
2018 you wrote the letter.
Yes.
Now according to the school submitted all the documents prior thereto in September 9, 2017.
That is the, my lord, school's version. I checked up. These were missing. I wanted.
No, you come to page 85. School submitted the date of birth and other particulars of all participants, and 15 numbers of candidates participated. Now out of them, 5 came out. First, second, third, fourth, fifth.
My lord, can I answer my lord's query?
Yes.
Page 85.
Hmm.
There is a tabular format. Marks are allotted on various things. Academic and training qualification, as per the recruitment rules. Certain marks are allotted. My lord, can I not check up based on the academic qualification and the mark sheets whether these calculations are correct or not? I ask this question to myself, my lord.
So mark sheet of all participants.
These are all innuendos. You are now trying to justify your conduct. Here, court is on discretionary relief. Court exercised discretion
Absolutely.
and thought that the wrongdoer must be penalized. Now you are taking sympathy waves. That see, I was not the only DI, but you in fact was the person in command at that time.
Not for
September 2017 to 2018. July 2017,
December.
December 2017 to 16th August
21.
21, yes. 17
to 21, almost
so
4
this
years.
during the entire period, as the matter was being delayed, school approached the court. So in the
COVID intervened. Office was closed.
where is your reply to the show cause?
Please take up, my lord.
Sorry, can you- Right.
Page 18 of my affidavit in reply. My lord, the last line.
Retired teacher, attendance register of the retired teacher against whom appointment was made. Attendance register of the retired teacher against whom appointment was made. এগুলো সব দরকার ছিল।
Clause C. Clause B. School authority should not produce any document in original regarding this matter. Attendance is acquittance rule. That information. Paragraph B. school could not produce any document regarding attendance register of retired teacher, acquaintance roll of monthly salary, PF statement, PF register. These are, where are the requirement of these?
My lord, they couldn't produce the sanction memo.
You have to see whether superannuated post created one, principal secretary has said, ask me to consider, I will pass.
The principal secretary, with the deepest of respect, my lord, said it in 2021.
Yes, that too after the school approached.
Yes.
Had they not approached, the matter would have been in the doldrums. But a responsible officer of the government, how can you, even if we divide into four officers, then also your responsibility comes of 1/4 of the amount.
The
5
difficulty is,
lakhs, 1/4 of the amount.
the difficulty is that, my lord, my office was closed, and I have stated that in my
When
reply to
was
show
it
cause.
Yes, you have stated we are going to. The government lockdown was from 23rd of March 2020. 2017 you are working.
2017 December.
December.
I had written thrice, my lord, to the school.
They say, school say, I submitted all the documents in September 2017. That is prior to joining the post. After you came in December, you এই চিঠিটা কোথায় গেল? পেজ 35 ও যে চিঠিটা দিয়েছে, ওই যে যেটা
87, 89, 94.
87. 87 letter was of 2018. So you started delaying. December 2017 charge taken. Now you are making, give me this document, give me that
That
document.
document, yes, in this way.
In this way, you kept it pending. They did not approach the court first. They approached you again. Still, you kept quiet. They show us one document by your representation calling upon the headmaster to produce A, B, C, D document as that is required under the government notification rules. Do you have any representation?
এইটা দেখুন, page 77, 78 and 79.
Hmm.
School gave 25 items.
Now
My lord, the recruitment rule suggests 25 items.
25. Cause of vacancy.
This is exactly, my lord, what I was asking for.
No, state, we are trying to find out the conduct of the state and intention of the state. So, Principal Secretary passed the order on 30th July 2021.
ফোকাসটা দিল 22/9/2020
DI কি সুকোষ করেছিল? DI কি সুকোষ করেছিল?
No. Page 18 is your reply to the show cause.
Yes.
Where is the show cause?
17 is the show cause.
17?
Yes.
সেটাও তো সেই দিনের দিন জবাব
জবাব দিল, হ্যাঁ, সুকোষ করলো, জবাব দিল করে।
তারপরে
22 নয়,
সেদিন কি জবাব?
সেদিন কি জবাব দিল?
এবার স্টেট বসে
স্টেপ বসে আছে এখন, 5 বছর হতে চলল।
কমিশনারের টাকা কি
কমিশনারের টাকা কি? আমি এটাও কন্ট্যাক্ট করি, এটাও রেকর্ড করে দিই। State is also not so serious. If the state is not serious,
responsibility established with he gave reply to the show cause on 22nd September 2021.
My lord.
And your commissioner allowed him to retire. That don't worry, I am with you.
In this point, my
22nd
lord,
September 21 was the show cause.
my lord.
He gave the reply to the show cause 21 on the same date. Now from 21 to 2025 when he retired, what did the commissioner do? Not a single thing he has done. Then you are also giving indulgence or premium to the misdeeds of the person. Huh? Yes, Mr. Dhol, senior advocate. What do you say? It is like birds of the same feather. Oh, they have told you all right. Give your reply to the show cause, I will keep it in the file. Yes, yes.
Has been passed, my lord, taking into consideration of the facts and facts, my lord, what has been, my lord, put before the court. So, my lord, if some order has been passed, but they have come up before this court, my lord, for they have to satisfy that these are not, my lord, these are not happened.
সাথে সাথে করে
এটা ফাইল করতে 22। It is public money.
But, I have attempted.
All.
I have
Your
attempted.
money also personally.
No, I have attempted to justify my conduct, my lord. I leave it to the discretion of your lordships. There's one mistake which I made. I retired on 30th November 2024. There's a mistake.
The money which the state has been forced to pay It is a from the public exchequer. It is the money of the all citizens. But the state has been forced to pay due to certain misconduct done by certain person.
I'm not the sole one.
You are the sole one. 13th of, because you entered in office on 21st December 2017.
There is no doubt about it.
Apart from the letter dated page 87 letter on 3rd July 2018, you have not been able to show us any letter.
My lord, page 89, page 94.
These are the 3 letters.
Yes. Thereafter, I write to my higher authority 112, 123, 127.
1
Page 87, 89, 94. Then 112. I report to my higher authority.
Page 112 is 112.
The matter was brought to the Commissioner of School Education 5th of June 2020.
One after another. You stated, you show us against whom the vacancy was created, in which they are appointed.
Yes.
In the month of January 2019. They also given in the 2019 list of 9. Yes. That Veronica appointed in place of such and such. Sagorika in place of such and such. Mousumi in place of such and such.
My lord, page 112 is followed by page 123.
One, 113.
My lord, 123 is followed by 127.
Conduct of your commissioner.
But, there is no letter, my lord, showing for your lordship that this has been to the satisfaction of the commission. There is no letter, my lord. One thing
Satisfaction of your focus.
I cannot see anything because the subsequent proceeding was not taken. Subsequent proceeding was not taken. That is there, my lord. But there is he is satisfied with the my lord, answer. That is also not reflected from the document.
No such communication has been issued by them. So your commissioner has allowed him to retire, paid the pensionary benefits.
There is no, my lord knows that if there is no, my lord, proceeding pending, we cannot, my lord, keep the thing.
Certainly, when it is an issue of monetary gain, you can certainly keep it. He has not he is withholding. He has been directed to be paid 5 lakhs. On the date of retirement, those orders were in force. You could have certainly started, instead of complication before retirement, you could have issued the letter. Now after retirement, he is taking a point, my pensionary benefits you have, now you are saying I cannot, so then it's a close-knit circle, no? Commissioner advised him to go and file a high court appeal so that I am also saved. He came and filed a See, 2022 appeal was filed. And you will also argue that what can I do, my lord? It was before you, my lord. How can I pass on? Conduct is not. No answer, Mr. Dole.
If by issuing a letter, if you withhold the 5 lakhs and something from his retirement benefit, and then that till the disposal of the appeal, the amount is withheld. Then what will happen? He would approach, he will file, he has already filed an appeal. So he was to file an application, bringing the subsequent fact to the. But showing tendency of this appeal, you also did not take any. Liability fixation. I am the sole responsible.
That is here.
কবে রাখবে সামনে শুক্রবারে
সামনে শুক্রবার আসলে কিন্তু আবার আমাকে 27 তারিখ হবে, তাহলে ওই 30 তারিখ বা নাকি
31 তারিখে
31।
The learned, we have extensively heard the learned advocate.
Same. 8 and 9.
8 and 9.
নেক্সট ম্যাটারটাতেও সেম দিয়ে দিও, ওনাদের অ্যাপিয়ারেন্স গুলো দিয়ে দাও। Mr. Dole, you ring up your commissioner and ask this question to him. If you get anything, you tell us. He will say also, I was not there in the post, Mr. Dole. I joined just now. How I can understand? That Mr. Day is very angry with you.
Now we shall hold, otherwise the state is not serious.
He is not serious. We will make a comment in our judgment.
and not inclined to recover that amount. Although this amount has been paid from public exchequer.
31 তারিখ PPM আছে না?
You will tell commissioner that court will hold it.
But I sent email to the department also. That copy is with me.
তাহলে কবে দেবো? 1 তারিখ দিয়ে দাও।
My lord's observation was there.
On first step.
First-
Without equivalent. Talk with him. Settle the issue. If it goes in favor of Mr. Banerjee, Mr. De, 5 lakhs.
I leave it to the.
No, don't leave it to us. You also consult your client. You also consult your client. We have finished your argument. We will take these bits and pass the order. Yes, next. Mr. De, be present on first. First, you will not be there.
Yes, my lord. Definitely. And I once again tender my unconditional apology, my lord. If something has erred, your lordship.
You are quite senior now.
No,
That
no, my
is
lord.
why we. That is why.
I still don't wear that gown.
That is our. We have been cast that duty. That any advocate, we tell the advocate, nothing, there is nothing adverse against any person. You are becoming senior, so anyway, yes.
Item 10, I appear for the appellant, but the other side is not here.
And as such, you are praying for adjournment.
But there's a resolution.
Today.
Not today. লিস্টটা ডেকে যাও। You are there, Mr. Chattopadhyay.
I am led by Mr. Vikas Ranjan Bhattacharya, and Mr. Bhattacharya already argued, completed his argument, my lord. That matter, Bardhaman University matter, my lord, they are
Temporary recruitment, they are asking for regularization.
and your lordship also passed
You will argue.
an order regarding.
You will argue.
I argued on behalf of the university.
Your argument also complete.
Yes, argument of both the parties concluded. On the last occasion, your lordship's pleasure was to just to refresh the matter once again. Since that so many times has already gone, just to refresh. So, and Mr. Bhattacharya also referred a decision of the Honorable Supreme Court. I also refer a decision regarding estoppel, that once I have been appointed as a temporary worker or in a temporary employment, I have been stopped from claiming the regular employment. And the most interesting part of this matter is, and your lordship's also a judgment of your lordship's division bench regarding Kolkata Port Trust regulation matter. But in all the matter, and the judgment referred, the latest judgment referred by my learned friend of the Supreme Court, that all those judgments are in connection with a permanent post and sanctioned post. In this particular case, my lord, this post were not sanctioned, and that is the reason on the last occasion it was a desire of your lordships to give a chart wherein
Now we can recall.
yes, my lord, I have already handed over a chart from 2015 to 2025, the position of the sanction post in the technical assistant of Bardhaman University. Initially, when the appointment was made,
there was only 2 sanction posts, and in respect of 2 sanction posts, 19 persons were appointed as a technical assistant. Though the advertisement says that this is a post is in the temporary nature, and the offer letter that is also says that this is
No, have you given that chart to Mr.
yes. Even today itself, I took a photocopy from him.
You have checked up.
Now, it is their contention that though they have been appointed as a temporary, but they are working as if a regular employee, and they are paying in a pay band manner, not a consolidated. So it is their argument, even though there is a 1-day break, but this is only a paperwork, but virtually it's a 365 days work. I think this is the main contention of my learned friend for last 10 years. But
in the service.
so only point, I am subject to my let's kind subject.
Now, my lord, putting to their chart. 25.
আবার আসছেও আরে এসছে রে
Right, let it be there, we take it up next week. Take it up next week. Next week এ কোনো date আছে তা fix করে দিয়ে
খুব ভালো but any day if your lordship please to fix them any day at 2 p.m. it's 2 p.m. or 3 p.m. kindly
13 তারিখে 1 তারিখ কি আছে
Monday Tuesday থাকবে ধরো Wednesday যদি থাকে
6 তারিখ কম মাইনিস না 6 তারিখ কম হয় সেদিন কি এটা Mr. Jawaharlal Dev, we have to hear. We don't know whether you
Order
can
কথা বলে মানে এটা অর্ডার মানে তো
কি order আছে দেখি।
হ্যাঁ ওইটাই তো
Mr. Chatterjee. No, do the please. And stated name. His presence will be resolution adopt করেছে। First half court should be lenient. Second half court should not do anything.
I have a plan to see a movie malad on the request of Mr. Chatterjee malad I cancel that.
What? Then you are, then will you, do you proceed? Because we have to hear Jawaharlal Dev also.
Yes.
Today you have adopted resolution in absence of any parties not to pass any. So if we pass
We
order,
can
then
finish it, but we cannot record Mr. Dev's states function.
you will say that I was not there. That things. So we are not passing any order. It would be better since you have adopted a resolution.
25th ওই 2 p.m. বলে রেখে দিও finished.
Grateful.
Please assist us with the memo and everything if you want to. You have given those documents, na?
Yes.
শোনো একটু পেপার টেক পাঠিয়ে দিও তো বুঝছো দেখো
Everything I took
হ্যাঁ
care. Everything.
এটা কপি আগে থেকে দিয়ে দেন না সুবিধা হয়
চাই তো বানা দিও
আমাকে দে অন্তত একটু সুবিধা করতে দে
তোমাকে দিয়ে দেবো
আমারও তো একটু পড়তে সুবিধা হবে
Mr. Chatterjee, you inform Jawaharlal Dev if on Monday it is taken up, we will hear.
Well, I will inform my law. I make a last occasion I
So
already.
simply let it be there. Let it be. We are not disturbing it. This is a first matter seen for the appeal hearing.
সোমবার মঙ্গলবার তো বিকাশটা
Let
নেই
it be there. You inform Mr. Jawaharlal Dev so that we can take up the matter. After the application, it
But problem is there, my lord. Monday and Tuesday, Mr. Bhattacharya is not there.
Oh. 25th, we have a matter fixed at 3 p.m. That is the original side bench. This is the difficulty.
But this matter will conclude within an hour malad it will not take more than an hour malad
hour.
not more than an hour
We have only 2.5 hours after recess.
Only half an hour.
2.5 hours we have.
No, half an hour.
Now you take one of out of the day.
2 p.m. malad it will conclude by 2:30
এপ্রিলে ফেপ্রিলে নাকি এপ্রিলে আবার যত এপ্রিলের দিকে যাবেন মিস্টার ভট্টাচার্য
If it is free, we will take it up on Wednesday. If Mr. Bhattacharya is in problem, you tell us. We will keep him. If he cannot, but we'll inform Mr. Jawaharlal. Let him. Yes, not today. Next. Take your list. Next. 16 তো হয়ে গেছে 16 order হয়ে গেছে।
15 I am appearing on behalf of the appellant. 15.
Yes, we take it up.
15 I am appearing on behalf of the appellant. And Mr. Ratul Biswas is appearing on behalf of the respondent.
We take it up next week.
All right, next week.
Yes, 16 টা তো হয়ে গেছে।
17.
17, my lord, I am appearing on behalf of the appellant led by Mr. Dotto, my lord. We are
Next,
filing our affidavit in reply.
who is it? File it on the next day.
My lord, the identical matter has been fixed after 6 weeks, my lord, so far.
This matter, the Dilip, the Ajanta Sharma matter,
This is your other side.
Who is the appellant?
We are the appellant.
No, he is
No, he is the
Mr. Chatterjee, you were there in
এটা তো আমরা তো appellant, মানে we are the appellants here.
ওইটা কোনটা বললো না সকালবেলা যেটা হলো 6 weeks বলে অর্ডার হয়ে গেল।
What of 16? 16 is already order passed. 16.
Yes, same order may be passed here also because
Oh, yes, yes.
16, I am not there.
5 and দুটো matter action. 5 and 16 order has been
6
passed.
and 16. 6 and 16.
This is the analogous, more or less analogous matter, but
Yes.
This is different, my lord. This is a teacher.
In respect of item number 16, we have condoned the delay and directed the respondent to file affidavit in respect of application for stay. Your junior was there.
yes, I
So if he named most probably order time.
17 is
Whether
a
your
teacher.
name has been-
Yeah, my client is a teacher.
6 আমরা কোনটা শুনছি 17 শুনছি না
17.
16 order হয়ে গেছে।
Yes.
Yes.
Mr. Chairman, Nag mentioned item 6, item 5.
Oh, okay, you in respect of 16, you are the appellant.
My
You give
junior,
your name. You give your name. Mr. Nag পেয়েছে তো নাগের।
এটা 17 ডাকছে 16 এ ওটা দাশগুপ্তকে রেকর্ড করে অর্ডার হয়ে গেছে।
5 and 16, yes, 5 and 16 was taken up, my junior was here, fortunately. So that matter has been fixed after 6 weeks.
সেকশন 5 ছিল বললো ইট ইজ আইডেন্টিক্যাল টু 50 যেটা এপিডেমিক ডিরেকশন হয়েছিল সেই জন্য we said it will be hard analogously 6 weeks.
17, the pleadings are complete.
This is not fully analogous, but issue is same.
Well, let the hearing
Let
of
them
17 take place because my client is without pension since 2021.
What I am saying,
The pleadings are over. Pleadings are over. On the last occasion, 4 weeks time was sought, my lord, for finding the reply.
my prayer would be, if this matter is taken up after those two matters, that will cut short your lordship's time also, court's time will also.
But if this is heard earlier, that will also cut short my lord's time.
Whatever I say, Mr. Chatterjee is opposing.
I want
That is
expeditious hearing.
That
That
he
is all.
always does.
Please
That
try
you
to
always
understand.
I am not
Law
at
points are all similar.
a failure to understand why
Only a
this should be
factual difference
deferred by.
Why we did not touch that matter
I'm grateful
when
for
we were
that.
told that you are appearing and you were not present, we knew that we will not pass any order in his absence. Try to understand the scenario.
My lord will also not adjourn the matter in my presence.
No, in a question is not that. Question was that identical issue involved two matters. We said analogously. Then it was told to us there is another matter. At the same time, it was told that in that Mr. Victor Chatterjee said that you are appearing. So we did not pass any order.
This concerns a teacher. My lord,
Right.
here the issue is
Next week,
different.
let it be there. If it reaches, we will hear.
I'm only anxious because he is without pension for 4 years,
Yes.
5 years.
Okay, not today because you have adopted a resolution. Whether any other parties are there?
University.
Yes, they are not here. Not today.
May we
Okay.
file your
File it on the next. Yes, next. Document.
Your other side.
Yes, 18 is we are keeping it.
Other side.
That is done. We are keeping it for the for others. Who was opposing you, Mr.
ছেলেটি সুমন 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 দে সুমন দে
Suman De?
কত নেই
Very Suman De. আমি এটাকে একটা we will pass our orders on 1st of April. তার আগে হ্যাঁ রেডি হয়ে গেছে হ্যাঁ ঠিক আছে 30 তারিখ কোনো 30 নেক্সট উইকে যে কোনো একটা
মে আই মাই লর্ড হ্যান্ড অফ মনীন্দ্র সিনহা যে কোনো
না না আজ বুধবার দিয়ে দিচ্ছি 25th কি আছে 25th দুটো
his service should be approved. Then, my lord, that
You
in the
concluded your argument. We only told Monindro we will consider. না ওটা দিয়ে দাও এই মনিন্দ্রটাকে ফাইলে রেখে Have you brought ML Kesri?
ML Kesri, my lord, one Srikanto, state of West Bengal, Srikanto.
না মনিন্দ্রটা থাকবে
না না আমি আমাদের ফাইলে
হ্যাঁ
No, ML Kesri I have not brought. Ramesh Chandra Bajpayee.
Yes, next.
Yes, next.
My Lord, 19, I'm appearing for the appellants in this matter. It is that matter that below 5 years for transfer. Your Lordship already heard the matter. It was kept under 4 orders. Probably some queries are left to be addressed, my Lord. That is why, my Lord, if your Lordship kindly.
Where he is working,
Mr. Sannal.
Mr. Shanal is for the board. I am for the council.
And my Lord, your Lordship already kept it for orders for passing the order, but some queries possibly your Lordship had. So, your Lordship wanted to hear it
Take it up on Monday.
Monday. Kindly takes it up, my Lord.
We'll be there.
Yes, my
Yes.
Lord. Monday. Great.
No, you did not. Did you give us any document to that effect?
No, your Lordship concluded.
Come on that day later. Ask him to be present. Where is Mr. Shanal?
My lord, Mr. Shanal is for the board. I will tell, I am for the council. My lord.
Oh, you are for the
Council.
very
No, item number 20.
My lord,
We are
20,
talking
that
about
matter.
item number 19. Yes.
With that matter, my lord, this private respondent was reinstated in the service and the Chittaranjan and Bhakta. My lord,
Last occasion, your lordship directed us to exchange affidavits, my lord. I'm filing my.
my lord, the affidavit has been, my lord, served on me, my lord, on 17th of March. Though there is a time bound
It's a little
manner.
bit late on my part.
My lord, I am only seeking 10 days time. My lord, I am coming.
ফাইলটা দাও একটু।
আমাকে একটু কপি সার্ভিস করলেন
হ্যাঁ, দিচ্ছি, দেবো। এই ওই লাল ফাইলটা দাও না, লাল ফাইলটা দিচ্ছি, তোমার একটা কপি দেবো, আমি রেখেছি, তোমার করেছি।
বুঝছেন
Right. কথা ছিল 27.
Petition on behalf of affidavit in opposition filed on behalf of the petitioner respondent
If your lordship kindly fix a time, my lord, date and time.
বিকাশ ওইটা বলো
বলছো। টাকা ঠিক করে
ওইটা যেটা
one record, my lord. My learned friend has submitted one border in connection with that writ petition, my lord. That one is required, my lord.
পাঁচ বছর দু সপ্তাহ টাইম নিচ্ছে তাহলে 2 সপ্তাহ আজ হচ্ছে ক তারিখ 20
To bring that record.
হবে
We have been allowed 2 weeks time.
3 তারিখ এপ্রিলের 3 তারিখ আবার ছুটি
তাহলে ওই 7, 8, 9, 10 এর মধ্যে একদিন থাকে।
হ্যাঁ 7, 8, 9, 10 এর মধ্যে একবার দেখে নিতে 7 থেকে 10 এর মধ্যে
31st বলছো তো।
না না চেঞ্জ করুন।
চেঞ্জ করছে?
দিনই পয়সা
কি ম্যাটার আছে?
In the meantime, my lord, the court will take that endeavor to bring that file, my lord.
No, no, it is not an endeavor on our part. You have told it.
My
We will. You have not filed any application to that effect.
No, my lord, I am not filed.
So let us see if it comes in normal course. We will. Otherwise, if you want to rely on certain document pertaining to that, you bring that document.
I'm getting.
আমরা নিয়ে আসবো।
Court is not there to collect document or evidence on
No,
for
my
the
lord, I'm not on that. I'm not on that. I'm not.
Your responsibility to bring.
তুমি এক কাজ করো আমরা নিয়ে আসবো যাচ্ছি
Recording চলে যাচ্ছে সেটা তোমার are present.
বলে দিন। 21 is the next matter. Mr. That quantum matter, lordship may recall,
Not done as yet.
not as yet. As the last chance was given, and it was assured before lordship by Mr. Tiwari that it will be complied with.
Order complied with.
Yes, Mr. Tiwari
Yes.
complied.
Is the compliance?
Lord, kindly say, yes, my lord, we have been complying with the order, my lord, we have been paying. We have paid, my lord. My lord, can you see, I have, this is my instructions, my lord, I have also annexed them, my lord, Xerox copies of the service book, which will show, my lord, the benefit has been provided to the applicants.
So long, what were you
My
submitting?
lord, this is the, my lord, absolute wrong communication, my lord, absolute wrong.
There must be a limit to this.
Absolute, I bow down to your lord.
Released, not response.
Absolutely.
We are believing your words, and now we have to believe some things which has been said to you after you made the submission.
So, my lord, actually, my lord, what
Limit to thake. You are holding a responsible post.
I am holding a responsible
Once
post, my
we
lord.
requested you, sir, take it, keep it on such and such, we are compliant. Now they are coming with an explanation telling the same advocate that now go and tell her, no, we have already complied.
Complied.
What is happening, sir?
Lord,
No discipline, no, and your advocates also should not be so afraid of these officers. You should have released retired from the matter.
Lord, the lordship kindly sees the
Once
something.
Mr. X tell Mr. Tiwari that go and tell this court to the court, tell this thing to
Well,
the
actually, what happened, my lord?
next day, Mr. Tiwari,
Subsequently, it was revealed from their service book, my lord, they have received the benefit. But they should have pointed out all these things before the court also. Instead of, my lord,
Mr. Tiwari,
Lord, kindly
Mr.
consider,
Tiwari, you
Lord,
are
I may be wrong, but
Tiwari,
they are also wrong.
we are not on right and wrong. We are on we are not right and wrong. On 2 occasions, it was on your statement. You said that I am taking it.
Necessary steps for its compliance.
Since you are there, we repose faith upon the
Yes, my lord,
subsequently, same person comes and says,
subsequently, after making, my lord, thorough inquiry and such.
he was sleeping. A principal secretary was sleeping.
That is the thing.
All right, you check up that, Mr. Doctor, and we will take it up on Monday. Yes.
Check up
Just now,
instruction.
Yes, I have supplied.
Yes,
Now, one copy has been handed over. I don't know what is there.
No, Mr.
Persist.
Dotto, you talk with your clients and come back to us. If that is not so, we will consider.
This
If it is if they have got something and they have not told you, that is also not proper. Anyway, you check up, Mr. Dotto.
calculation has to. This
No, no.
Affidavit of compliance filed on behalf of.
My lord, not affidavit of compliance, my lord. These are instructions, my lord.
It is not affidavit of compliance.
No, my lord. But this is the instructions, my lord, along with my lord, relevant documents, my lord.
Mr. Thierry Lanet advocate produce certain documents and submits that the order has already been complied.
এই দেখি একটু ফাইলটা দাও।
Stop. Our
No, they say, no, if I have understood Mr. Tiwari correctly, he said there was no content because the order, there was no scope for content because it was not, content was never committed. So the compliance doesn't arise.
Submitted a status report issued by the assistant director administration.
contemner নয় তো।
Is the contemner this
assistant director administration contemner?
Near officer?
No.
Let it come from the, the authority on oath.
Well, in that case, I'll file affidavit.
Let it come from the, this.
Okay, you check.
Mr. Dotto,
You check.
if we now allow them for affidavit, they would be taking another 4 weeks. Status report has been filed. We are only recording that. This is a status report which the advocate has given us, signed by the assistant director with a copy to him.
Mr. Thierry Lanet, senior advocate appearing for the alleged contemner or not?
Contemners.
Alleged contemners submitted status report and certain documents along with certain document.
Is 22.
22. 22, 34.
Next, তারপরে
শুধু 22.
25 and 26.
Well, 22, my lord. I'm just, my lord, requesting your lordship, my lord, to take it up in this matter after 29th. Because, my lord, in this matter, my lord, Mr.
Tell it us on Monday. When it is called on, you tell us it. They take it up.
22.
Well, 20,
Yes,
26, 27.
we have kept it, not today just.
Both sides here.